The Woman in the Apron. A story about the moment justice stopped asking for permission. She walked into that courtroom wearing a housekeeper's apron, still damp from her morning shift, and every single person in that room laughed at her. Every single one. They filmed her on their phones. They whispered. A billionaire's fate hanging in the balance, and the only person willing to stand up for him was a woman who cleaned hotel rooms for a living. What they didn't know, what they couldn't have known, was that Nia Carter had been preparing for this moment her entire life. They just never gave her a room to prove it. If you've ever been underestimated, counted out, or told to stay in your lane, this story is for you. Stay until the end, drop a like, and tell me in the comments, what city are you watching from? I want to see how far this story travels. The Woman Who Stood Up. The laughter started before she even reached the gate. It rippled through this gallery in waves. First a few suppressed snickers near the back, then a growing current of amusement that spread row by row until even the bailiff near the door had pressed his lips together in that particular way men do when they're trying not to smile at something they know they shouldn't find funny. Cell phones came out. There were at least 6 of them that Nia Carter could count from where she stood, their screens catching the cold fluorescent light of Courtroom 14B in the Southern District of New York. All of them pointed at her like accusations. She was still wearing the apron. She hadn't planned it that way. When the call had come through, a frantic, half-coherent message from a voice she barely recognized, she'd been 40 minutes into her morning shift at the Meridian Grand on West 57th, stripping pillowcases in room 1104 with the efficiency of someone who had learned long ago that speed was the only thing that kept her schedule from collapsing entirely. She'd had 17 more rooms to finish before noon, a school pickup at 3:15, and a pot of rice soaking on the stove back in her apartment in the Bronx that she absolutely could not afford to let burn again. She had not planned to end up in federal court, but here she was. The apron was white cotton with thin blue stripes, hotel issued, and there was a small rust-colored stain near the bottom left corner from where she'd knocked over a bottle of iron supplement 3 weeks ago and never quite gotten it out. She was 28 years old. She was 5 feet 4 inches tall. She had her mother's cheekbones and her grandmother's jaw and eyes that people consistently described as serious in a tone that made clear they considered it a problem. Her hair was pulled back in a neat bun that was beginning to escape at the temples, and she had not slept more than 4 hours the night before because Marcus had an ear infection and cried until 2 in the morning. She looked, in other words, like exactly what she was, a tired woman who had come a very long way from wherever she was supposed to be. Order. Judge Patricia Alderman's voice cut through the gallery noise with the practiced efficiency of someone who had spent 23 years not being ignored. She was a small woman with silver-streaked hair and reading glasses pushed up on her forehead, and she had the particular stillness of someone who had seen enough courtroom theater to be unmoved by almost anything. Almost. Even she was watching Nia with an expression that had not yet decided what it was. "I will have order in this courtroom, or I will clear it. Is that understood?" The laughter settled into silence, but it was the kind of silence that still contained amusement, a held breath, a bitten cheek. The phone stayed out. Nia kept walking. She was aware of every step she took across that marble floor. She could feel the weight of the room pressing against her from all sides. The gallery packed with journalists and spectators, and people whose suits probably cost more than her monthly rent. The plaintiff's table with its 3-attorney formation arranged with the geometric precision of people who were very used to winning, and at the center of it all, the defense table, where Grant Whitmore sat alone. Grant Whitmore. Even now, even like this, accused, publicly humiliated, the subject of a fraud case that had occupied the front pages of every major financial publication for the past 4 months. Even now, he looked like what he was. 61 years old, broad-shouldered, silver-haired in the way that money made distinguished rather than old. He was wearing a charcoal Brioni suit that probably cost $8,000, and his posture was the posture of a man who had sat at the head of tables his entire life and had simply never learned how to occupy less space. He had the kind of face that appeared on the covers of magazines with words like Titan and Visionary printed beneath it, and he was staring at Nia Carter with an expression she recognized immediately. It was the same expression people always wore when they first looked at her. Calculation. Then dismissal. She had learned over 28 years that the dismissal was always the mistake. "Ma'am, The bailiff moved to intercept her before she reached the gate. He was a broad man with kind eyes and the automatic wariness of someone whose entire job was managing the unexpected. "Ma'am, you can't—" "My name is Nia Carter," she said. Her voice was steady. She had worked very hard, for a very long time, to make her voice steady in moments when her hands wanted to shake. "I'm here to speak on behalf of the defendant." The silence in the gallery changed texture. It stopped being amused and became something more electric, more uncertain. "Ma'am, I understand the situation." She looked past the bailiff to the judge. "Your Honor, I understand the defendant's attorney has not appeared. I understand this creates a significant problem for the proceedings, and I'd like to address the court directly if I may." Judge Alderman studied her over the reading glasses. "And what is your bar admission status, Ms. Carter?" "I am not currently a licensed attorney, Your Honor." The murmur from the gallery this time had teeth. Nia heard someone near the back say something she chose not to parse. The plaintiff's lead attorney, a man named Douglas Freed, whose reputation for theatrical courtroom performances had earned him a profile in New York Magazine the previous spring, leaned back in his chair and folded his hands across his stomach with the satisfaction of a man watching a problem solve itself. "Your Honor," Freed said, in the voice he used when he wanted to sound both reasonable and unavoidable, "perhaps we could simply proceed with a continuance until proper counsel can be—" "Mr. Freed." Judge Alderman's tone did not invite elaboration. She was still looking at Nia. "Mrs. Carter, are you familiar with the concept of pro se representation?" "Yes, Your Honor. I'm also familiar with the Sixth Amendment right to counsel, the limitations on unlicensed practice under New York Judiciary Law Section 478, and the court's discretionary authority to permit non-attorney assistance in limited circumstances under direct judicial supervision." She paused. "I attended Columbia Law School for 2 years before circumstances required me to withdraw. I have continued independent study since that time. I am prepared to demonstrate that familiarity if the court will permit it." The silence that followed was different from any of the silences that had preceded it. It was the silence of a room recalibrating. Judge Alderman's expression did not change. That was one of the things about her that people who came before her consistently failed to anticipate. But something shifted behind her eyes. She turned to the defense table. "Mr. Whitmore," her voice carried no particular warmth, "your counsel of record, Mr. Victor Hale, has not appeared. His office has not responded to the court's attempts at contact. Do you have any information regarding his whereabouts?" Grant Whitmore's jaw tightened almost imperceptibly. "No, Your Honor, I do not." "Are you in a position to retain new counsel for this proceeding?" A pause. Something moved across his face. Frustration, Nia thought, and beneath it, something more raw. He was, she realized, genuinely frightened. Men like Grant Whitmore were not accustomed to being frightened, and they were even less accustomed to showing it, and the combination had produced in him a kind of rigid, contained tension that she recognized from the faces of people who had been told by doctors that the news was not good. "I cannot retain new counsel before this morning's session, Your Honor," he said. "I would request a continuance." "Mr. Freed?" The judge turned to the plaintiff's table. Douglas Freed spread his hands in a gesture of generous reluctance. "Your Honor, the plaintiff has been waiting 4 months for this case to move forward. We have witnesses scheduled. We have costs associated with this proceeding that continue to accumulate." He smiled the smile of a man who already knew the answer. "We would object to any further continuance." Judge Alderman was quiet for a moment. The courtroom held its breath. "Ms. Carter," she turned back to Nia, "you're proposing to assist Mr. Whitmore in an advisory capacity, under direct court supervision, for today's session only." "Yes, Your Honor, with the court's permission and with the defendant's consent." "This is highly irregular." "Yes, Your Honor. So is the disappearance of defense counsel on the first day of trial." Another murmur from the gallery. Judge Alderman did not smile, but the lines around her mouth shifted in a way that suggested she had noted the point. "Mr. Whitmore." The judge's eyes moved back to the defense table. "Do you consent to this arrangement?" Grant Whitmore looked at Nia Carter for a long moment. She looked back at him without blinking. She had learned not to blink in moments like this. Blinking was how you let people see the uncertainty. She watched him make the calculation. She watched him look at the apron, at the escaped strands of hair at her temples, at the absence of a briefcase or portfolio or any of the material signifiers that in his world separated people who were taken seriously from people who were not. She watched him look at Douglas Freed's satisfied expression and then back at her. She watched him decide that a woman in a housekeeper's apron was, against all probability, his best available option. "Yes," Grant Whitmore said. "I consent." The cell phones came back out. The murmuring rose. Someone in the gallery whispered, "Is this real?" to the person beside them, and Naya heard it clearly because she had developed, over years of working in rooms where she was meant to be invisible, an acute sensitivity to the things people said when they thought you couldn't hear them. She opened the gate and walked to the defense table. "Mr. Whitmore," she said quietly, pulling out the chair beside him, "I need you to look completely unsurprised right now. Like you planned this." He turned to look at her with an expression that was, in that moment, utterly unguarded. "Did you?" he asked. "Plan this?" "No." She set her phone on the table. Her phone, which she had downloaded 240 pages of SEC filings onto at 6:30 that morning because she'd had a feeling, a very particular feeling, that the day was going to require it. "But they don't know that." Something shifted in his expression. Not warmth exactly. That would come later, slowly, and only after it had been earned on both sides. But something. A reconsideration. He straightened his jacket, turned forward, and looked, if not entirely unsurprised, then at least no longer defeated. The case against Grant Whitmore, as Nia had spent the past 6 weeks understanding it, 6 weeks during which she had purchased every available court filing from the public docket, printed and annotated them at the library on Jerome Avenue, and spread them across her kitchen table on the 3 nights per week when Marcus slept at his grandmother's, was built on a single devastating document. The document was a contract addendum, dated 18 months prior, in which Whitmore Capital Group allegedly committed to a revenue-sharing agreement with a tech startup called Helix Ventures that would entitle Helix to a 23% stake in any derivative IP developed using Helix's proprietary data architecture. The addendum, according to Helix and their attorneys, had been signed by Whitmore personally and subsequently buried, the revenue diverted, and the entire arrangement concealed from Helix's board until a whistleblower surfaced the document 8 months ago. The case had attracted significant media attention. Helix was a sympathetic plaintiff, a scrappy innovation company with a diverse founding team and a feel-good origin story that journalists loved. Whitmore was a less sympathetic defendant, a billionaire with a reputation for aggressive deal-making and an extensive paper trail of hard-nosed negotiations that opposing counsel had characterized in their public filings as a pattern of exploitative behavior toward smaller entities. The narrative wrote itself. The public had already delivered its verdict before the opening arguments. What the public did not know, what Nia had spent 6 weeks trying to verify, was that the metadata on the document didn't match. It was a small thing, the kind of thing that required patience and a particular kind of methodical attention to find. The kind of attention, she had learned, that came naturally to people who had spent years doing jobs that required them to notice what other people overlooked. Douglas Freed's opening statement ran for 45 minutes and was, she had to acknowledge, excellent. He was a skilled performer. He knew how to pace his delivery, when to slow down for emphasis and when to accelerate, how to use silence as punctuation. He walked the jury through the timeline with the clarity of a man who had rehearsed this story until it had achieved the deceptive simplicity of inevitability. He displayed the addendum on the courtroom's projection screen. He showed communication logs, wire transfer records, a series of internal emails from Whitmore Capital that painted a picture of deliberate concealment. Beside her, Grant Whitmore sat very still. "He's good," Whitmore said, very quietly, during a moment when Freed paused to take a drink of water. "He knows the version of the story that makes sense," Nia said, without looking up from the screen. She was watching the addendum. She had been watching it for several minutes, cross-referencing it against the image she had studied on her phone screen at 2:30 in the morning 2 weeks ago, when she'd finally found the thing that had been bothering her. "The problem is there's another version." He glanced at her sidelong. "And you can prove it?" "I have the beginning of it. The beginning is enough to crack the foundation." She kept her eyes on the screen. "After that, the rest of it opens up." That's a very confident statement for someone who isn't a lawyer. I never said I wasn't a lawyer, she said. I said I wasn't licensed. He was quiet for a moment, then unexpectedly, why did you leave Columbia? She didn't answer immediately. The question was personal in a way that the morning had not yet been, and she was not yet sure she owed him personal answers. But there was something in the way he'd asked it, without condescension, without the particular flavor of curiosity that people usually deployed when they asked about her background, the kind that was really asking, how did someone like you end up somewhere like that made her consider it. My mother got sick, she said finally. Then the tuition ran out. Then Marcus came. She clicked her phone to the next document. I had to make choices. I'm sorry, he said, and she believed him, which surprised her. Don't be, she said. I kept studying. Fried concluded his opening. The judge called a brief recess before the defense's opportunity to respond. It was 20 minutes. 20 minutes during which Naya sat at the defense table with her phone and her annotated printouts and tried to organize into linear sequence the argument that had been forming in her head for 6 weeks. Grant Whitmore watched her work. At one point, one of the junior attorneys from the plaintiff's table walked past on his way to the water cooler and glanced at her materials. The printed-out PDFs with handwritten margin notes, the color-coded sticky tabs, the phone propped up against a coffee cup displaying a spreadsheet. And his expression was the expression of someone who had walked into a room expecting to find a mouse and found, unexpectedly, something else entirely. He walked back to his table and said something quietly to Douglas Fried. Fried glanced over. His expression didn't change, but something behind his eyes did. Good, Nia thought. Let them recalibrate. When the recess ended, Judge Alderman looked at the defense table. Ms. Carter, you may make an opening statement on behalf of the defendant, understanding that this statement is made under the court's direct supervision and that the defendant retains full responsibility for its contents. Thank you, Your Honor. Nia stood up. She was aware, in the way you were aware of things that were important, that this was the moment. Not just for Grant Whitmore and his case, but for something larger, something she hadn't quite named yet, but that she could feel pressing at the edges of the morning like light under a door. She walked to the center of the floor. She did not have notes. She had not had time to write notes. Everything she was about to say existed in the architecture of a mind that had been, for 10 years, its own best library. She looked at the jury, 12 people whose faces were a study in suspended judgment, ranging from polite skepticism to outright confusion about what they were seeing. An elderly man in the second row had his arms folded across his chest. A younger woman near the center was leaning forward slightly, the way people did when something had caught their attention against their will. Ladies and gentlemen, Nia said, my name is Nia Carter. I am not Mr. Whitmore's regular attorney. His regular attorney is unavailable. A beat. She saw the corner of the elderly man's mouth twitch. So I'm what you've got today, and I know what that looks like. I know what you're thinking right now. She paused and let the silence be exactly as long as it needed to be. You're thinking, this woman is wearing an apron. Laughter, genuine, surprised, not unkind, moved through the jury box. Even the elderly man's arms uncrossed slightly. I'm going to ask you to do something that I know is difficult, she continued. I'm going to ask you to look past what you expected this morning and look instead at what the evidence actually shows. Because what the plaintiff's counsel has given you is a very compelling story. It makes sense. It has a clear villain and a clear victim. It has documents. She glanced at the projection screen where the addendum still lingered. But I want to ask you about that document. Not what it says, about what it is. Because a document can say anything. What matters is where it came from. She turned back to the jury. The addendum that Mr. Fried has described as the center of this case, the document that, according to the plaintiff, Grant Whitmore signed, buried, and profited from, that document has a metadata signature, a digital fingerprint. Every document created on a computer does. And the metadata on that addendum tells a story that is very different from the one you heard this morning. She walked slowly, giving the words time to land. It tells a story about a document that was revised, modified, changed, after the date it bears, not before, after. She stopped. And the revision didn't come from Mr. Whitmore's office. The gallery was absolutely silent. We will show you the timeline, she said. We will show you the IP routing, the version history, the pattern of legal language in this addendum that doesn't match. Not in style, not in structure, not in the specific terminology. Any of the 112 contracts that Grant Whitmore's legal team has produced over the past 15 years. We will show you that the language in this addendum is consistent with a different legal tradition entirely, a different drafting style, a different set of professional habits. And we will ask you to consider the question that this evidence raises. She faced them directly. If Grant Whitmore didn't write this contract, who did? And why does it matter so much to someone that he take the blame for it? She returned to the defense table and sat down. The courtroom remained quiet for a moment that lasted exactly long enough. Then it erupted. The judge called lunch recess at 12:40. Douglas Freed stood immediately and walked to the defense table with the deliberate unhurriedness of a man who had decided to appear unthreatened. "Ms. Carter," he said. He was taller than she'd expected up close, 6 feet, easy, with the kind of groomed handsomeness that looked like it had cost money to maintain. His suit was navy, his watch caught the light. "That was an interesting opening." "Thank you," she said. "Theories you've developed about document theories you've developed about document metadata are going to require expert testimony to be admissible." He paused. "Do you have an expert, Ms. Carter?" She looked up at him. "Do you have a client who didn't alter a document, Mr. Freed?" His expression didn't flicker. He was very good. "Have a pleasant lunch," he said, and walked away. Beside her, Grant Whitmore let out a long, controlled breath. "He's rattled," he said quietly. "Not rattled," she said. "Recalculating." She picked up her phone. She had 17 missed messages, 3 of which were from her mother asking about Marcus's medication schedule, one of which was from her supervisor at the Meridian Grand wondering where she was, and none of which she had time to address. "There's a difference. You've done this before." "No." "You've done something like this before." She considered that. "I've spent a lot of time in rooms where I wasn't supposed to be," she said finally. "You learn to read the room." He was quiet for a moment. Then, "I didn't sign that addendum." "I know." She set her phone down and looked at him directly. "Someone went to a great deal of trouble to make sure it looks like you did. What I need to know is who benefits from your conviction. Not from your embarrassment, not from your reputation taking a hit, from your actual conviction. Who needs you gone that badly?" Grant Whitmore held her gaze for a long moment. Something moved across his face. The particular expression of a man who had spent a long time trying to keep a certain door closed and was now being asked to open it. "There's a company," he said, "Arcturus Holdings. They've been trying to acquire 3 of my subsidiary firms for 2 years. I've refused every offer." He paused. "The CEO is a man named Raymond Chalk. He does not handle refusal well." Nia wrote the name down. "Tell me everything you know about Raymond Chalk," she said. He did. They were still talking when the bailiff returned to call the afternoon session, and Nia had 4 pages of notes in her careful, compressed handwriting, and somewhere in those 4 pages was the edge of a thread she could pull. The afternoon session was harder. Douglas Freed called his first witness, a forensic accountant named Dr. Gerald Moss, who had the patient, slightly sorrowful manner of a man who delivered bad news for a living and had made his peace with it. Dr. Moss walked the jury through 18 months of financial transfers with the thoroughness of a surgeon, tracing the movement of funds from Helix Ventures accounts to Whitmore Capital subsidiaries to offshore holding structures with the kind of clarity that made complex financial crime feel as uncomplicated as a grocery list. It was damaging, very damaging. Even with the metadata question left hanging in the air from the morning, even with the jury clearly uncertain about what to make of Nia's opening, the numbers were numbers. The money had moved. Freed let Moss's testimony breathe, let it settle into the room like weather. When it was Nia's turn to cross-examine, she stood up and felt, in a way she had felt only a few times before in her life, the particular vertigo of a moment that was going to decide something. She walked to the center of the floor. "Dr. Moss," she said, "the financial transfers you've described, they began when, specifically?" "The first transfer occurred in March of the year prior to this proceeding. And the addendum, The contract addendum that the plaintiff's counsel has presented as the authorization for this revenue arrangement, it's dated January of that same year? That's correct. So the addendum predates the transfers by 2 months? Yes. Doctor Moss, in your review of the financial records associated with this case, did you examine the payment structure of Whitmore Capital's operating accounts for the period prior to January of that year? Freed was on his feet. Objection, Your Honor. Relevance. Your Honor, Naya said without turning around, the witness has testified to a financial timeline. I'm examining whether that timeline is internally consistent. I'll allow it, Judge Alderman said. The witness may answer. Doctor. Moss adjusted his glasses. I examined the operating accounts? Yes. And are you aware that Whitmore Capital's standard contract cycle, their internal process for executing new revenue-sharing agreements, typically involves a legal review period of between 60 and 90 days before funds are authorized to move? A pause. That's a general characterization I've seen referenced, yes. So if the addendum was signed in January and the standard review cycle runs 60 to 90 days, the earliest funds could have moved under Whitmore Capital's standard operating procedure would be April, he said slowly, to May. But the transfers began in March. Silence. The transfers began in March, Nia repeated for the jury, before Whitmore Capital's own legal review process would have concluded, meaning that if Grant Whitmore had signed this addendum and routed it through his own firm's standard process, the money would not have moved when it did. She paused. Dr. Moss, does that strike you as consistent with a deliberate scheme by Grant Whitmore to execute and conceal a fraudulent agreement? Or does it raise questions about whether the agreement was processed through his firm's systems at all? The silence in the courtroom had a different quality now. Freed was on his feet again, objecting, and Judge Alderman was sustaining it, but the question was already out, and it had landed where she'd intended it to land. She returned to the defense table. Whitmore leaned slightly toward her. That was good, he said quietly. That was the beginning, she said. We need the rest of it. She looked at her notes. Arcturus Holdings, Raymond Chalk, a Zurich packet, a locker code. She had an idea about where to look next. The session concluded at 4:40. Outside on the courthouse steps, the cameras found her before she'd cleared the door. A half-dozen journalists with microphones and the particular forward lean of people who had been standing in one spot for 5 hours waiting for something to happen. Ms. Carter, what's your response to the plaintiff's financial evidence? Ms. Carter, are you planning to continue representing Mr. Whitmore? Ms. Carter, what are you doing here? Who are you? She kept moving. She was good at moving through spaces without stopping. That too was something she had learned in the service of other people's needs. Behind her she heard a voice. Naya. She turned. Grant Whitmore was standing at the top of the steps, his security detail hovering at a respectful distance. He had descended from his usual atmosphere enough to look, for a moment, simply like a man who was tired and had not quite expected the day to go the way it had. Thank you, he said. It cost him something. She could see that. Men like Grant Whitmore did not often have occasion to mean those words, and the unfamiliarity of them showed on his face. Don't thank me yet, she said. We have a long way to go. She looked at him steadily. I need access to your document management system, your contract archives, specifically anything that touched the Helix negotiation before the addendum was produced. Can you arrange that? He studied her. You're going to keep going. Someone made a very specific set of choices to put you in that room today, she said. I'd like to understand the full architecture of those choices. She pulled her coat tighter against the November wind off the Hudson. Also, I need to get home. My son has an ear infection. Something crossed Grant Whitmore's face that she wasn't quite ready to name. I'll have the access arranged, he said. Tonight, if you want it. Tonight, she confirmed. She walked down the courthouse steps toward the subway, the cameras trailing and the city swallowing the noise, and inside her chest, something that she hadn't felt in a very long time. Not hope exactly, but its precursor, the particular alertness of a mind that had finally found the problem it was built to solve, was burning very steadily. She had a lot of work to do. She had always had a lot of work to do. The difference now was that someone was finally watching, The subway home took 47 minutes, which was 47 minutes of standing in a car that smelled like wet wool and exhaust, holding the overhead bar with one hand, and scrolling through Whitmore Capital's publicly available SEC filings with the other. Her thumb moving in small, precise gestures across the cracked screen of a phone that she'd been meaning to replace for 8 months and hadn't, because replacing it cost money, and money was not something she had in quantities that permitted that kind of discretion. Around her, the other passengers did what subway passengers did. They slept, or stared at their own phones, or stared at nothing with the particular 1,000-yard focus of people who had learned to be somewhere else while being here. Nobody looked at her. She was a woman in a work apron on the D train at 5:15 on a Tuesday evening, and she was invisible in the way she had always been invisible in public spaces, the way that had once been a source of quiet grief and had eventually become something she understood as a kind of advantage. Invisible people, she had learned, could look at things for a very long time without anyone asking them to stop. She got off at Tremont Avenue and walked the 4 blocks to her building with her head down against the November wind, and when she climbed the 3 flights to apartment 3C and pushed open the door, she was met immediately by the sight of her mother, Dora, standing in the kitchen with her arms folded and an expression that communicated without a single word the full weight of an afternoon she had not signed up for. "Before you say anything," Naya started. "I called the hotel," her mother said. "They said you walked out in the middle of your shift." "I didn't walk out. I told Sandra I had a family emergency and I'd make up the hours." "A family emergency?" Dora unfolded her arms just enough to gesture toward the living room, where Marcus, 6 years old and radiating the specific miserable energy of a child with a fever, was asleep on the couch under the blanket with the race cars on it. "Your family emergency is right there, and it has a temperature of 101. "I know, Mama." Nia set her bag down and went immediately to the couch, pressing her palm against Marcus's forehead. He stirred, but didn't wake. He was warm, not burning. Better than the night before, she thought. Did he take the amoxicillin at 2? He took it. He didn't want to, but he took it. Dora came to stand in the doorway between the kitchen and the living room, watching her daughter with an expression that had been arguing with itself for several decades and had never entirely resolved the conflict. "The news was on, Nia." Nia kept her hand on Marcus's forehead. "I know. You were on the news." "I know, Mama. In your apron." "I know." She straightened up and turned to face her mother. Dora Carter was 54 years old, with a face that had started out beautiful and had aged into something better, stronger, more specific, marked by the particular kind of knowledge that could not be acquired anyway except by living long enough to earn it. She was looking at her daughter the way she always looked at her when something large had happened, with a mixture of pride and terror so evenly balanced that neither one could win. "Grant Whitmore," Dora said, testing the name like she was checking whether it was hot. "You were in federal court today defending Grant Whitmore. In an advisory capacity, under direct judicial supervision. Naya. I know how it sounds." "Do you?" Her mother's voice was not loud. It never was, which made it more effective. "Because what it sounds like is my daughter, who works a 7 to 3 shift cleaning hotel rooms and raises a child on her own and hasn't had a full night of sleep since I can remember, decided today was the day to walk into a federal courtroom and take on a case that has 3 partner-level attorneys from one of the biggest firms in the city on the other side." 4, Nia said. Freed brought a 4th in for the afternoon session. Her mother stared at her. "I noticed things," Nia said, "about the case, things that didn't add up. I've been following it for 6 weeks. Following it. In my own time. Evenings. The library on Jerome, they have Westlaw access." She watched her mother's face. "I know you think I stopped." Dora was quiet for a long moment. The refrigerator hummed. From the couch, Marcus made a small sound in his sleep and pulled the race car blanket tighter around himself. "I never thought you stopped," her mother said finally, and her voice had changed. The argument in it had settled, at least temporarily, into something more complicated. "I always thought that was the saddest part." They looked at each other across the small living room, across the 6 years, and the decisions and the accumulated weight of everything that had been given up and everything that had been held on to. "I have to go back tomorrow," Nia said. Her mother closed her eyes briefly. Then she opened them. "I'll be here at 7, she said. "For Marcus." "Mama." 7 o'clock, Nia. "Have his lunch packed." She went back to the kitchen. Nia stood there for a moment, breathing, and then she went to the table where her printouts lived in a stack that had been threatening to become something she needed a filing system for. And she sat down, and she got back to work. The access to Whitmore Capital's document management system arrived at 9:17 in the form of a secure link sent to an email address she'd given to Whitmore's executive assistant, a woman named Patricia Chen, who had communicated exclusively in complete sentences and with the professional neutrality of someone who had been trained to have no discernible opinions about anything. The link opened onto a read-only portal containing 26 months of contract archives, version histories, internal routing logs, and correspondence threads tagged to the Helix Ventures negotiation. Nia made coffee. She checked on Marcus, still sleeping, cooler to the touch, his breathing steady. She sat back down at the table. What she was looking for was a signature, not a handwritten one, something more granular and more difficult to fabricate. Every legal document produced by an organization with consistent internal practices carried the fingerprints of its own conventions. The way numbered clauses were formatted, the specific boilerplate language used in limitation of liability sections, the spacing conventions in signature blocks, the style in which dates were expressed. These things were as distinctive as a firm's handwriting, and they were almost never consciously noticed by anyone, which made them, when you knew what to look for, exceptionally useful. She had spent parts of 3 nights over the past 2 weeks examining the publicly available contracts associated with Whitmore Capital. She had looked at acquisition agreements, licensing deals, vendor contracts, non-disclosure agreements. She had looked at 12 years' worth of them, working chronologically backward, noting in her careful handwriting the patterns that repeated and the ones that didn't. She had built, painstakingly and without anyone asking her to, a kind of linguistic fingerprint for how Whitmore Capital's legal team wrote contracts. And then she had looked at the addendum. The addendum used the Oxford comma differently. It was a small thing, absurdly small, the kind of thing that should not matter, that no one would ever bring into a courtroom as evidence, except that Whitmore Capital's contracts, in 12 years of documents she had examined, never once used the Oxford comma in enumerated lists of obligations. Not once. It was not a rule anyone had written down. It was a habit, the product of a particular drafting culture, as automatic and invisible as breathing. The addendum used it 4 times. That alone proved nothing, but it was the beginning of the thread, and as she worked now through the internal archives, the version histories, the routing logs, the draft trails, the thread kept pulling loose from the fabric. The addendum had been routed through Whitmore Capital's document management system, yes. It had a file path and a creation timestamp and all the attributes of a document that belonged there. But the version history, the internal record of every edit made to the file, which most document systems maintained automatically, showed something that did not match the story around it. The document had been created on a Tuesday afternoon in January. It had been modified twice in the following 48 hours. And then, 6 days later, it had been modified a 3rd time. That 3rd modification had occurred at 11:43 in the morning. It had lasted 4 minutes and 27 seconds, and the IP address associated with it was not a Whitmore Capital address. Nia stared at that IP address for a long moment. It wasn't definitive. IP addresses could be masked, rerouted, proxied, but it was a data point, and it was a data point that raised a very specific question. And the question was, who had accessed this document from outside Whitmore Capital's network 6 days after its creation, and what had they changed? She wrote the IP address down. She looked at the timestamp. 11:43 in the morning on a Thursday in January, from a location that was not Whitmore Capital's offices. She turned to the correspondence thread. There were in the archive 412 emails associated with the Helix negotiation over the preceding 26 months. She was not going to read 412 emails tonight. Marcus needed his 7 o'clock antibiotic, and she needed at least 3 hours of sleep, and she was also aware that she was a single human being and not a team of associates. But she could filter. She could look for the messages that bracketed the modification date. She found 12 emails sent in the 3 days surrounding the 3rd modification. She read them carefully, twice. 11 of them were routine, scheduling, document requests, status updates. The 12th was different. It was an internal message from a name she didn't recognize, a name listed in the system as D. Larson, associated with a role described as contract coordination specialist. And it said, in full, Zurich packet confirmed. Routing as discussed. Please advise on timeline for locker. Nia read it 3 times. Then she opened a new note on her phone and wrote, D. Larson, contract coordination specialist, Zurich packet, locker. She sat back in her chair and looked at the ceiling of her kitchen, which had a water stain in the shape of something that Marcus had decided was a dinosaur and which she had been meaning to have the super look at for 5 months. She thought about the word locker. Iman. The next morning arrived with the particular brutality of mornings that follow nights, during which you did not sleep enough. A gray light through curtains that didn't quite meet. Marcus already awake and requesting cereal and asking with the relentless investigative curiosity of a 6-year-old why she was still in her clothes from yesterday. Her mother arriving at 7:03 with coffee from the bodega on the corner and the expression of a woman who had decided, at least for this morning, to ask no questions. Nia changed clothes in 4 minutes. She briefed her mother on the amoxicillin schedule, kissed Marcus on the top of his head, told him she would see him at dinner, and was out the door by 7:15. On the train downtown, she did 2 things simultaneously. She composed a message to Patricia Chen requesting the employment records for a D. Larson in Whitmore Capital's contract coordination department, and she looked up the IP address from the document modification. The IP address was registered to a commercial VPN service. That was expected. A sophisticated operation would route through a VPN. What was less expected was that the VPN provider, when she searched it, had been cited in 3 separate legal proceedings over the past 4 years for its association with offshore financial operations. One of those proceedings involved a company that had been acquired by a holding firm called Arcturus Capital Partners. Arcturus Capital Partners. She read that twice. Then she pulled up everything she had on Arcturus Holdings, the name Grant Whitmore had given her on the courthouse steps, and cross-referenced it against the search results. Arcturus Holdings was not the same entity as Arcturus Capital Partners, but they shared 2 board members, a registered agent in Delaware, and a law firm. The law firm was called Mercer Strand LLP. She wrote that down. The train pulled into Chambers Street, and she stood up and tucked her phone into her coat pocket and walked toward the courthouse with the particular forward lean of someone who had a great deal of ground to cover in not very much time. She was back at the defense table by 8:55, and Grant Whitmore arrived at 9:03, this time with a leather portfolio under his arm and, she noticed, a second cup of coffee, which he set down in front of her without comment before taking his seat. She looked at the coffee, she looked at him. Patricia said you requested Larson's employment records, he said. He was keeping his voice low, natural, the practiced quiet of a man who knew how to talk in rooms where people were listening. We don't have a Larson in contract coordination. We've never had anyone by that name in contract coordination. I know, she said. That's the point. He looked at her steadily. Explain. The name D. Larson is in your document management system as the sender of an internal email referencing something called a Zurich packet and a locker. But there's no employee by that name, which means the account was created specifically to send that message, and then, presumably, to disappear. She pulled out her printed notes. The email was sent 3 days before the document modification I found in your version history. The modification came from an external IP address routed through a VPN with documented connections to Arcturus adjacent entities. Grant Whitmore was very still for a moment. It was a different kind of stillness from the defeated stillness of the day before, but more focused, more familiar. This was the stillness of a man who had run large organizations and was recognizing, in someone else's analysis, the outline of something he had suspected but couldn't prove. Raymond Chalk, he said. Raymond Chalk, she confirmed. I'm not there yet. I don't have a direct line from that IP address to anyone at Arcturus, but the architecture is starting to show. She looked at him. The Zurich packet. Do you know what that refers to? He thought for a moment. Then something shifted behind his eyes. 18 months ago, there was a negotiation, nothing to do with Helix involving a Swiss licensing arrangement. It fell apart. There was a document package assembled for that deal that included several proprietary contract templates we'd developed internally. He paused. Those templates had our drafting conventions built into them. Someone who had access to those templates could use them to create a contract that looked like it came from your firm, Naya said. But that wouldn't explain the differences in drafting style you described yesterday. No, she said, because whoever altered the addendum didn't just copy your templates. They modified them. And the modifications introduced language from a different drafting tradition, British-influenced contract law, the kind you'd see from a firm with offshore practice. She paused. Which brings me back to Mercer Strand. She watched the name land on his face. You know them, she said. They've represented Arcturus in 2 of the acquisition attempts, he said. His voice had gone very quiet. You think Mercer Strand drafted the addendum? Well, I think someone with access to a British-influenced drafting style, with a knowledge of your internal contract templates from the Zurich negotiation, and with the technical capability to insert a fabricated document into your document management system via an external VPN, created a fraudulent addendum, then constructed a financial paper trail that made it look like you'd acted on it. She laid her notes on the table in front of him. That's what I think. What I need is the evidence that proves it. He looked at her notes for a long moment. There was a quality to his attention, a completeness to it, the way he was not performing engagement but simply engaging, that she recognized from the best minds she had encountered. The professors at Columbia who had made her feel like thinking was the most important thing in any room. The Zurich packet, he said. There were physical copies, document packages. My assistant at the time, say, a man named Patrick Selway, he managed the assembly and distribution of those packages. Where is Selway now? He left the firm 14 months ago. I assumed he'd taken another position. He paused. Now I'm wondering. Naya looked at her notes. 14 months ago, 2 months before the addendum was dated. I need to find Patrick Selway, she said. The bailiff called the room to order. Across the aisle, Douglas Freed straightened his jacket and opened his portfolio with the unhurried confidence of a man who had not yet been given reason to hurry. The morning session was difficult in a different way from the afternoon before. Less theatrical, more grinding. Freed called a digital forensics expert who walked the jury through the electronic signature trail on the addendum with methodical, credentialed precision. He was good. He answered Nia's cross-examination questions with the patient certainty of someone who had testified many times and had learned that the way to defeat a cross-examination was simply to be very sure of everything you said and to say it calmly. She got 2 things from him that she needed. The first was his acknowledgement that electronic signature trails could be fabricated by anyone with sufficient access to an organization's document management infrastructure. The second was his admission, reluctant and carefully qualified, that the forensic process he had used to verify the signature had not independently verified the IP origin of the initial document creation. It wasn't enough to sink his testimony, but it put cracks in the certainty of it. Freed re-examined. He shored up the cracks. He was methodical and thorough and excellent. By the lunch recess, Nia's notes had expanded by 11 pages, and her coffee was cold, and the yellow legal pad she'd borrowed from Whitmore's portfolio had a corner that was beginning to curl from the pressure of her handwriting. In the corridor outside the courtroom, she found a quiet alcove near the water fountains and called the number she had for a journalist named Terrence Webb, who covered financial crime for a digital publication called The Current, and who had, 2 years ago, written a piece on offshore corporate structures in which he had cited research that she suspected, given the specificity of his sourcing, had required access to exactly the kind of document trails she was now following. He picked up on the second ring. This is Webb. My name is Naya Carter, she said. You were in the courtroom this morning. A beat. I was, he said. And you are. Not what I expected. Nobody ever is, she said. I need to ask you something. 18 months ago, was there any reporting, anything at all, published or unpublished, on a negotiation between Whitmore Capital and a Swiss licensing entity? Something that might have been referred to internally as the Zurich packet? She could hear him thinking. It was a specific quality of silence, the kind that meant the person on the other end was actually consulting their memory rather than performing consideration. There was something, he said slowly. I heard about it third hand. A deal that fell through, something about proprietary data rights. It never went anywhere publicly. Were there document packages? Physical ones? I heard there were. I couldn't verify. Terrence. She kept her voice even. I need to find Patrick Selway. He was Grant Whitmore's assistant 14 months ago. He left the firm around the time this whole thing started moving. I think he knows where those document packages went. Another silence. Why are you telling me this? Because if I find what I think I'm going to find, I'm going to need someone to hold a copy, she said. Someone outside the legal process who can make sure the information doesn't disappear. A long pause. Then, you think someone's going to try to make it disappear? I think someone has already tried very hard to make the truth disappear, she said. I think they're going to try harder when they realize it didn't work. She heard him exhale. I'll make some calls about Selway, he said. And Miss Carter, Naya, what you did in there this morning, the forensics cross, that was real lawyering. I know, she said, and hung up. The afternoon brought the anonymous call. She was back in the alcove, 20 minutes before the afternoon session began, going over her notes on the Larson email, when her phone rang from an unknown number. She had received unknown number calls before. Collection agencies mostly, the lingering aftermath of a credit card she had used during Marcus's first year when the math simply hadn't worked. And she had developed the habit of answering them with neutral efficiency and dispatching them quickly. Nia Carter, she said. The voice on the other end was male, low, with an accent she couldn't immediately place. Flat, Midwestern, the careful erasure of regional origin that people adopted when they wanted to sound nowhere in particular. Ms. Carter, the voice said, you had a very interesting morning. She felt the shift in her chest. Not fear exactly, more like recognition. The recognition of a pattern she had suspected was there and was now confirming. I did, she said. She kept her voice level. She had learned to keep her voice level. It would be a shame, the voice continued, if tomorrow morning was less interesting for you. Is that a threat? It's an observation. A pause. You're a housekeeper, Ms. Carter. You have a 6-year-old son with an ear infection. You have an elderly mother who depends on you. You have a job that you walked out of today, and jobs like that aren't easy to come by. Another pause, more deliberate. You have a life. It would be unfortunate to see that life become complicated. She was quiet for a moment. She was aware of the corridor around her, the midday foot traffic of the courthouse, lawyers and clerks and journalists and anxious family members of defendants, all of them moving through the institutional light of a place where the business of judgment was conducted. I appreciate the call, she said. Ms. Carter? No, genuinely. I appreciate it. She was surprised to discover that she meant it, because it tells me something I needed to know. What's that? That I'm close enough to something that someone needed to make this call. She paused. Have a good afternoon. She hung up. She stood in the alcove for 30 seconds, very still, breathing deliberately. Her hands were not shaking, which was a thing she noted with the detached awareness of someone monitoring their own systems. Good. Not shaking. Good. Then she called her mother. Mama, she said when Dora picked up, I need you to do something. I need you to take Marcus to Aunt Vera's tonight. Not your place. Vera's. And I need you not to tell anyone where you're going. A beat. Nia, what's happening? I think someone is going to try to intimidate me into stopping what I'm doing. Then stop what you're doing. Her mother's voice was sharp with the particular edge of a woman who had spent decades being afraid for her child and had very specific thoughts about the intelligence of continuing in a direction that was generating threats. Mama, Nia's voice was quiet. You know I can't do that. The silence on the line was long and layered. 7 o'clock, her mother said finally. I'll have him at Vera's by 7. Thank you. Don't thank me, just a pause. Just be careful. She went back into the courthouse. She sat down at the defense table. She opened her notes to the page where she'd written D. Larson. Zurich packet. Locker. She underlined the word locker 3 times. When Grant Whitmore arrived and settled into the chair beside her, he looked at her face and said, without preamble, something happened. I got a call, she said. Anonymous, warning me to stop. His jaw tightened. Nia. It confirmed something, she said. She did not look up from her notes. She had found, in the course of the past 24 hours that she did not particularly want Grant Whitmore's concern, not because she was ungrateful for it, but because she had learned over 28 years of navigating the world without much of a safety net that other people's concern, however genuine, was not something she could afford to lean on. It was something she filed away and returned to later, in the privacy of her own accounting. It confirmed that there's something real at the end of this thread. The call doesn't scare you? She considered the question. It does, she said. Of course it does. I have a son and a mother and a life that doesn't have a lot of margin for error. The call scares me. She looked up at him. But I was scared yesterday too when I walked in here. I was scared before I stood up and said I would defend you. Being scared is not the same as stopping. Grant Whitmore looked at her for a long moment with an expression she still couldn't entirely read. Something in the neighborhood of respect, she thought, but more interior than that, more unsettled. Like a man who had built very specific beliefs about the world and was finding that the world was quietly revising them. The afternoon session began. She spent it watching the plaintiff's witnesses carefully, taking notes, and thinking about a locker. That night, after the session ended, and she had confirmed that Marcus was safely at Aunt Vera's in Yonkers and had eaten his dinner and taken his antibiotic and was asking to watch a movie about dinosaurs, which Vera permitted because Vera had always been the lenient one, Nia sat at her kitchen table with a fresh pot of coffee and opened the document archive again. She read every email thread associated with the Zurich negotiation. She read the scheduling records, the meeting notes, the travel logs for the period when Patrick Selway had still been employed at Whitmore Capital. She read a document package checklist that had been produced for the Swiss licensing deal, itemized in the kind of careful detail that Patrick Selway, based on everything she could piece together about him, seemed to have been constitutionally incapable of not providing. On page 3 of the package checklist, in a field labeled Physical Distribution, were the names of 6 individuals who had received hard copies of the Zurich packet. 5 of them were Whitmore Capital executives or outside counsel. The 6th was listed as R. Chalk, care of Arcturus Holdings, for preliminary review. Nia read it 3 times. Raymond Chalk had received a copy of the Zurich packet, a package containing Whitmore Capital's proprietary contract templates, 14 months before the fraudulent addendum appeared, officially marked as part of a preliminary review for a potential business relationship that, as far as she could determine from the public record, had never materialized. He had the templates. He had known what they looked like, and he had apparently known someone with the technical capability to modify them in ways that would be very difficult to trace. She sat back in her chair. She thought about the word locker in D. Larson's email. Please advise on timeline for locker. She thought about what kind of locker, in the landscape of a complex document manipulation scheme, would require a timeline. Not a gym locker, not a school locker. Something that held something that needed to be picked up or accessed or transferred. A private storage service. Something accessed by code. Something that could hold physical documents or a USB drive. She picked up her phone and called Terrence Webb. Did you find anything on Selway? She asked. Working on it, he said. He's gone quiet. No LinkedIn, no new employer I can trace. But I found a forwarding address from a building in Midtown where he had a mailbox. The mailbox is registered to something called Lark Administrative Services. Lark Administrative. She wrote it down. That's a mail forwarding service? Mail forwarding and private storage. They have a location on West 34th. He paused. The kind of place where someone might keep things they didn't want at their home address. She looked at the word locker on her notepad. She looked at Lark Administrative Services. Terrence, she said, I think I know where to look. Then we should probably talk about how you're going to get in, he said, because you're not a licensed attorney, and what you're describing sounds a lot like you're thinking about approaching a private storage facility with evidence that's relevant to a federal case. I'm a member of the public conducting research, she said. Nia. I know the line, she said quietly. I know exactly where it is. I'm not going to cross it. She paused. But I need to know what's in that locker before I can get anyone with official capacity to take it seriously. Right now, all I have is a thread. I need the rest of the cloth. Webb was quiet for a moment. Then, "Be careful," he said, "and call me when you know." She set down the phone. She looked at her notes. The water stain on the ceiling that Marcus had decided was a dinosaur stared back at her in the lamplight. She thought about the anonymous call, the careful, nowhere accent, the references to Marcus, to her mother. She thought about Patrick Selway, who had disappeared 14 months ago and was apparently receiving mail at a private services address in Midtown. She thought about Raymond Chalk, who had received a copy of the Zurich packet and had, sometime in the intervening months, decided that the most efficient path to acquiring Whitmore Capital's subsidiaries was not negotiation but destruction. She poured more coffee. She turned to a new page. She wrote at the top, "What does the locker contain?" And then, below that, she wrote the answer she was beginning to suspect. Everything. She went to Lark Administrative Services on Wednesday morning, before the courthouse, while the city was still in that particular early state of itself. The garbage trucks, and the delivery vans, and the people who worked the invisible infrastructure of New York, moving through streets that had not yet filled with everyone else. It was 6:45, and the sky above the buildings on West 34th was the color of old pewter, and the wind off the Hudson had a quality that went past cold into something more deliberate, the kind of cold that felt like a message. Lark Administrative occupied the second floor of a building wedged between a dry cleaner and a shipping store, accessible by a narrow staircase that smelled like carpet cleaner and the accumulated presence of 1,000 ordinary transactions. The woman at the front desk was somewhere in her 50s, with reading glasses on a beaded chain and the expression of someone who had spent enough years managing other people's private business to have developed a comprehensive policy of not being interested in any of it. "I'm looking for a mailbox registered to Patrick Selway," Naya said. She had her phone out, and on it she had pulled up the email from Terrence Webb with the forwarding address, or possibly to Lark Administrative Services itself. The mail may have been routed through a business account. The woman looked at her over the reading glasses. "We don't share customer information." "I understand that," Nia said. "I'm not asking you to share his information. I'm asking if you have a storage unit registered in that name, because I believe there may be materials in that unit that are relevant to a federal proceeding, and if that's the case, the court is going to be issuing a subpoena for your records within the next 24 to 48 hours. She held the woman's gaze. "I'm not asking you to give me access to anything. I'm asking you to preserve whatever is registered to that name until the proper legal process catches up." A long pause. The woman's expression didn't change exactly, but the quality of her attention shifted. "Are you law enforcement?" she asked. "No." "Are you an attorney?" Nia thought of the 2 years at Columbia, of the 10 years since, working through casebooks in library corners while Marcus napped, and the world went about its business of not noticing. "I'm working with the defense in a federal fraud case," she said. "United States District Court, Southern District of New York. The case number is—" "I know the case," the woman said. Nia waited. The woman took off her reading glasses and folded them on the desk with the precision of someone making a decision. "There's a unit registered to a business account," she said carefully. "Lark Administrative is listed as the registered agent for a number of client accounts. I can't tell you who those clients are." She paused, and this pause was deliberate. The pause of a person who had decided, in the arithmetic of this particular moment, that precision and obstruction were not the same thing. "What I can tell you is that a unit accessed by a code designated in a client account has not been accessed in 11 months. And if a court were to issue an order for its contents, those contents would be available." "The code," Naya said. "If someone had that code—" "Anyone who has the access code for a unit is authorized to open it," the woman said. Her voice was absolutely neutral. "That's our policy." She put her reading glasses back on and returned to her computer. Nia stood at the desk for a moment, looking at the woman's averted face, at the careful blankness of someone who had just said exactly as much as they were going to say. She went back down the stairs. She stood on West 34th Street in the pewter morning and looked at her notes. The email from D. Larson. "Please advise on timeline for locker." The note in Patrick Selway's calendar, which she had not yet seen but which the outline of events was beginning to suggest existed, referencing a code. She needed the code. And to get the code, she needed Patrick Selway. And to find Patrick Selway, she needed something she didn't yet have. She had 2 hours before she needed to be in court. She called Terrence Webb. "He's in Jersey City," Webb said. He sounded like a man who had not slept, which she was beginning to understand was his natural register. "I found him through a lease application on a building management database. It's public record in New Jersey if you know where to look. He's been there 10 months. Ground floor apartment on Morgan Street, registered under his middle name, which is Daniel. Daniel Selway. Patrick Daniel Selway. He stopped using Patrick when he moved." A pause. "That's not something people do when everything is fine." "No," she agreed. "It's not." She was already moving, already doing the calculation. Jersey City was 20 minutes by PATH train from the World Trade Center stop. If she left now, she could be there and back before 9. Barely. "Terrence, I need you to do something for me." "I'm listening." "I need you to come to Jersey City with me, right now." She was at the subway entrance, her MetroCard already out. If Selway is going to talk to anyone, it's more likely to be a journalist than someone connected to Whitmore. And I need a witness. A beat. "You're asking me to come with you to knock on the door of a man who disappeared from his life 10 months ago and is connected to a scheme that someone just made anonymous threats over." "Yes." Another beat. "I'll meet you at Exchange Place in 20 minutes, he said. Patrick Selway answered the door in the kind of clothes that said he hadn't been expecting anyone. Sweatpants, a Columbia University hoodie that had been washed enough times to go soft at the elbows, socks. He was 32 or 33, Nia guessed, with the particular look of someone who had been thin and had become more so, and eyes that assessed the two people on his doorstep with the immediate, flinching wariness of a man who had been waiting for a knock on the door for a long time and had never entirely decided what he would do when it came. He looked at Nia. He looked at Terrence, who was holding a notebook because he had decided that a journalist holding a notebook looked more like what it was than a journalist holding a phone. He looked back at Nia. "You're her," he said. "You're the one from the trial." "I am," she said. "My name is Nia Carter. This is Terrence Webb. We're not law enforcement. We're not connected to anyone who wants to hurt you. We just need to talk." He gripped the door frame. She could see him running the calculation. The familiar arithmetic of someone weighing what they were afraid of against what they were more afraid of. "How did you find me?" he asked. "Public records," she said. "Which means someone else could find you too if they looked. I'd rather be the first." Something moved across his face. He stepped back from the door. They went inside. The apartment was neat in the way that places were neat when someone had very little and had organized that little with care. A second-hand couch, a clean kitchen counter, a stack of books on the floor beside the window that looked out onto a narrow strip of urban courtyard. There were no personal photographs on the walls. There were no objects that looked like they had been collected for pleasure or sentiment. It was the apartment of a man who was living somewhere temporarily, waiting for a situation to resolve that he no longer believed would resolve. He made coffee without asking if they wanted it, which Nia took as a sign that he needed something to do with his hands. She sat on the couch. Terrence sat beside her. Neither of them spoke while he moved in the kitchen, and the silence was the kind that allowed a person to arrive at a decision at their own pace. Selway brought 3 mugs and sat in the chair across from them and looked at the floor for a moment. "I didn't know what they were going to do with it," he said without preamble. "I want that on record, from the beginning. I didn't know the full plan." "Tell me what you did know," Nia said. He wrapped both hands around his mug. "About 16 months ago, I was approached by someone from Mercer Strand, a junior associate, I won't say the name right now. I'm not ready to say the name right now, who told me there was a financial arrangement available if I could facilitate access to certain document packages from the Zurich negotiation." He paused. "I knew it was wrong. I knew what I was doing. I'm not going to pretend I didn't." "Why did you do it?" Terrence asked. His voice was even, non-judgmental. He was, Nia thought, a good interviewer. Selway was quiet for a moment. "My mother has early-onset dementia," he said. "The facility she needs, the one she's in right now in Connecticut, costs $11,000 a month. I was making $62,000 a year at Whitmore Capital." He lifted his eyes. "I'm not asking for sympathy. I'm just telling you the arithmetic." Nia held his gaze. She knew that arithmetic. She had lived a version of that arithmetic. She didn't say so. It wasn't the moment, but she filed it away in the part of her that understood people. The document packages, she said. You gave them the Zurich packet. I gave them physical copies of the contract templates, the full package that had been distributed to the preliminary review list. He hesitated, including the copy that had been sent to Raymond Chalk. You gave it to Chalk directly? No, I gave it to the Mercer Strand associate. What they did with it after, I told myself I didn't need to know. But you know now, Nia said. He nodded slowly. They used the templates as a base, modified them, inserted the addendum language. Someone with serious technical capability handled the document management system insertion. That wasn't me. I don't have those skills. I just provided the originals and the access code to the document archive for the Helix negotiation files, so they could understand the folder structure. He paused, and I assembled the locker package. The room was very quiet. Patrick, Nia said, and she kept her voice very steady. What's in the locker? He set down his coffee mug. He looked at her with the expression of a man who had been carrying something heavy for a very long time and was now in the presence of the first person who had come looking for it, considering whether to put it down. Everything, he said. He gave her the code. He gave it to her written on a piece of paper torn from a notepad, in handwriting that had the particular quality of someone who had written something many times in their head before committing it to the page. He had kept it, he explained, because he had understood from the beginning that the day might come when the thing he had done would require him to either disappear entirely or produce something that demonstrated the full scope of what had been planned, something that made clear he was a pawn rather than the architect. There's a USB drive, he said, and a sealed envelope. The envelope has a memo inside it, an internal Arcturus document that I was given by mistake. The associate sent it to me along with the payment confirmation, I think as a way of making sure I understood the seriousness of what was involved. Maybe to implicate me further. I don't know. He shook his head. The memo outlines the full strategy. The litigation budget, the acquisition timeline, the offshore routing plan. It has Chalk's name on it. Chalk signed the memo? Terrence said. Initialed it. At the bottom. It's not a signature, but it's his initials and it's his letterhead. Selway looked at Nia. The USB drive has the draft contracts, the ones that show the evolution of the addendum, the original Whitmore template, the intermediate versions with the Mercer Strand modifications, the final fraudulent version. The metadata on those drafts is intact. Nobody cleaned it because nobody expected the drive to be found. Nia felt something move through her chest. Not triumph, not yet. Something more like the specific sensation of a very large piece falling into the place where it had always needed to be. Why didn't you go to the FBI? She asked. Why didn't you go to anyone? He looked at her for a long, tired moment. Because I was involved, he said. Because I gave them the templates. Because I gave them the access code. Because I took the money. He rubbed his face with both hands. And because the day after I assembled the locker package, someone from Mercer Strand called me and told me that if I ever said anything to anyone, my mother's facility would receive an anonymous complaint about billing irregularities, and the investigation alone could result in her transfer while it was resolved. And a transfer, at her stage, he stopped. At her stage, a transfer could kill her. The room held that sentence for a moment. They threatened your mother, Nia said. They know how to find leverage, he said. That's what they do. She thought about the anonymous call. You have a 6-year-old son with an ear infection. She thought about the careful, nowhere accent, the list of things that mattered to her recited back as warnings. She thought about the architecture of intimidation, how it was always the same, always aimed at the same thing, always relied on the same fundamental bet, that love was a vulnerability, that the people who mattered to you were the bars of your cage. I want you to write down everything you just told us, she said. Everything. In your own words as completely as you can. I want you to sign it and date it, and I want Terrence to witness it. And then what? He asked. And then I'm going to retrieve the locker contents and submit them to the court with forensic verification. And you're going to testify with whatever protective arrangements I can get the court to put in place for you and your mother. She paused. Patrick, I know that's a frightening thing to ask. I know what it costs. But what they're doing, what they built, It doesn't stop with Grant Whitmore. If Chalk can do this once and win, he does it again, to someone else. And the next person who ends up in that courtroom might not have anyone to stand up for them. Patrick Selway looked at her for a long time. "You believe you can actually win this," he said. It wasn't quite a question. "I believe the truth is in that locker," she said. "Everything else follows from that." He picked up the notepad. He began to write. She retrieved the contents of the locker at 8:47 in the morning, 12 minutes before she needed to be on the PATH train back to Manhattan. The woman at the front desk of Lark Administrative did not look up when Nia entered. She did not look up when Nia walked back past her desk 11 minutes later, carrying a sealed envelope and a small USB drive in a plastic sleeve. She did not look up, but Nia noticed, as she passed, that the woman's computer screen showed a page she had not been on when Nia first arrived. A page that looked, at a glance, like it might be a facility access log. She was protecting herself, Nia understood, making a record of who had come and when and what the code had opened. Being the kind of careful, quiet, observant person that the world consistently underestimated. She recognized the type. On the PATH train back to Manhattan, she held the envelope and the USB drive in her lap and did not open either of them. She was aware, with the clarity that came from having studied enough law to understand the architecture of procedure, that the integrity of these materials mattered as much as their contents. She could not be the person who had looked at them in a moving train car. She needed verification. Forensic, documented, chain of custody verified. She needed to do this correctly. A memo with Chalk's initials and Anne. A memo with Chalk's initials and an internal Arcturus acquisition strategy. A USB drive with the draft evolution of the addendum. She watched the Hudson appear and disappear in the train windows. "I have Patrick Selway's written statement. He'll testify." A longer silence. When Whitmore spoke, his voice had changed. Not softened exactly, but compressed, the way voices got when a person was managing something large and didn't want the management to show. "How did you find Selway?" "Carefully," she said. "I need your digital forensics people. The real ones. Whoever you use for litigation support. I need them to verify the USB drive contents and produce a documented chain of custody before I submit anything to the court." "Can you make that happen today?" "I can make it happen in 2 hours," he said. "I need it in 90 minutes. A beat. "I'll make it happen in 90 minutes. She arrived at the courthouse at 9:04, 3 minutes before the session began, slightly out of breath, still carrying the envelope and the USB drive. She sat down at the defense table and looked at Douglas Freed, who was reviewing his notes with the settled confidence of a man who had not yet had reason to revise his confidence. She looked at the envelope in her hands. She thought about Patrick Selway on his second-hand couch in Jersey City, his mother in a facility in Connecticut, the $11,000 monthly arithmetic of love. She thought about Dora Carter and Marcus in Aunt Vera's apartment in Yonkers, and the anonymous voice listing her vulnerabilities like a checklist. She thought about Raymond Chalk, who had looked at all of this, at the people in the machinery of it, at Patrick and Grant and the 12 jurors and the gallery full of journalists, and had calculated that the efficient solution was to make the truth simply disappear. She set the envelope on the table and placed her phone on top of it and waited for the judge. The morning session was a continuation of the plaintiff's case. 2 more witnesses, both from Helix Ventures' side, who testified to their experience of discovering the alleged concealment, the distress it had caused the company, the financial harm they claimed to have suffered. They were credible witnesses. They had not manufactured their distress. Whatever else was true about this case, Helix Ventures had genuinely believed they had been wronged, and that belief was real and human and present in the room. Nia cross-examined both of them with care and with a specific kind of respect that she hoped the jury could feel, not attacking their experience, not minimizing what they believed had happened to them, but asking the questions that subtly reoriented the frame. Who had first brought the addendum to their attention? A whistleblower, the first witness confirmed. And that whistleblower, had they come from inside Helix Ventures? A pause. No, the witness admitted. The whistleblower's identity had been protected, and their employment history had not been disclosed. Had anyone at Helix independently verified the addendum's authenticity before filing the suit? Another pause. Their attorneys had verified it, the witness said. Which attorneys? Freed's firm, the witness acknowledged. Fried re-examined efficiently, repairing the frame she had cracked. He was good. She acknowledged it again, internally, with the honest assessment of someone who understood what she was up against. At the lunch recess, Whitmore's forensic team, 3 people in dark suits carrying equipment cases, with the focused, quiet efficiency of surgeons, met her in a conference room on the 4th floor that Whitmore's executive assistant had somehow arranged access to. She handed over the USB drive and the envelope. She watched them work. They documented everything, the condition of the materials, the chain of custody from her hands to theirs, the opening and initial imaging of the USB drive's contents, the careful unsealing of the envelope under portable document lighting. The forensics lead was a woman named Dr. Yolanda Marsh, compact and methodical, with the specific authority of someone who spent her professional life being the last word on contested facts. She looked at the USB drive's contents and did not react exactly, but her posture changed, the way posture changed when the data confirmed what it needed to confirm. "The metadata on these draft documents is intact," she said. She was talking to her tablet as much as to Nia, narrating for the record. "I'm seeing 4 distinct version iterations of a contract addendum. The first version is internally consistent with Whitmore Capital drafting conventions. The second and third versions show progressive modification, the introduction of Oxford comma usage, clause numbering format changes, limitation language that doesn't match the first version's style." She scrolled. "The 4th version, the final version, matches the document in evidence." "And the modification timestamps?" Nia asked. "All 4 versions carry creation and modification timestamps. The file path metadata shows origination from an external network, not Whitmore Capital's infrastructure." Dr. Marsh looked up. "Someone created these drafts outside Whitmore Capital's system and then inserted only the final version into their document management portal. Can you verify the IP routing? I can trace it to a VPN node. Whether the endpoint behind that node can be identified will require additional forensic work and likely a court order." She paused. "But the draft evolution alone, the documented progression from Whitmore Capital's authentic templates to the fraudulent final version with timestamps and external network metadata, that's significant evidentiary material. Significant enough for a court submission?" Dr. Marsh considered the word. "Compelling," she said. "Compelling enough that I would be prepared to testify to its authenticity under oath." Nia looked at the memo from the envelope, which Dr. Marsh had photographed and was now examining under document lighting. It was 2 pages, single-spaced, on Arcturus Holdings' letterhead. The language was direct in the way that internal documents were direct when they were not intended to be read by anyone outside the room. No performance, no euphemism, just the clean administrative language of a plan being executed. The memo described what it called a litigation leverage strategy. It outlined the insertion of fraudulent contractual obligations into Whitmore Capital's legal exposure, the use of a fabricated whistleblower to surface the addendum, the financing of the Helix suit through an offshore intermediary, and the intended outcome, a criminal conviction for Grant Whitmore that would destabilize his firm, trigger default provisions in several key partnerships, and enable Arcturus to acquire the target subsidiaries at distressed prices. At the bottom, below the final paragraph, were 2 handwritten initials, R.C. Raymond Chalk. "I need certified copies of everything," Nia said. "Documented chain of custody, signed certifications. I need all of it by 2 o'clock. "You'll have it," Dr. Marsh said. She submitted the materials to the court at 2:17 in the form of a defense motion with the full forensic documentation attached, requesting immediate admission of new evidence and leave to present it before the plaintiff concluded their case. She submitted it, as she submitted everything, in the careful, organized handwriting of someone who had learned that the presentation of a thing was as important as the thing itself, that the court needed to see not just what she had found, but that she had found it correctly, that the process by which the truth had arrived was as unimpeachable as the truth itself. Judge Alderman reviewed the motion at the bench for 11 minutes. The courtroom was very still. Fried was on his feet within 30 seconds of seeing the motion land on the clerk's desk, and he remained on his feet for the full 11 minutes with the controlled energy of a man fighting the physical urge to do something he couldn't yet do. When the judge looked up, she looked at Nia first. "Ms. Carter," she said, "the materials you've submitted, The forensic certification, the USB drive contents, the memorandum, these were obtained how, specifically? Through a private storage facility, Your Honor, accessed via a code provided voluntarily by a material witness who has also provided a signed statement and indicated willingness to testify. She kept her voice level. The chain of custody is documented from the moment of retrieval. The forensic certification was produced by a qualified digital forensics expert whose credentials are included in the submission. And the witness? Patrick Daniel Selway, formerly a contract coordination specialist at Whitmore Capital. His full statement is in the submission. Freed was speaking before she finished. Your Honor, this is a procedural ambush. The defense is presenting materials that were not disclosed in discovery, obtained through methods that have not been vetted, introduced mid-trial without Mr. Freed. The judge's voice was not loud. It didn't need to be. You'll have your opportunity? She turned back to Nia. The witness, Mr. Selway, is he available to testify? He is, Your Honor, subject to appropriate protective arrangements for his personal circumstances, which are outlined in his statement. Another pause. Judge Alderman looked at the submission. She looked at Freed. She looked, finally, at the jury, who had been watching the entire exchange with the acute, slightly bewildered attention of people who had come to see one kind of movie and found themselves in a completely different one. I'm going to call a brief recess, the judge said. I'll review the submission in full. We'll reconvene at 4 o'clock, at which point I will rule on admissibility. She looked at Freed. Mr. Freed, I'll hear any procedural objections at that time. In writing, please. She descended from the bench. The gallery erupted. In the noise of it, the voices, the phones coming out, the reporters angling toward the aisle, Nia sat very still at the defense table with her hands flat on its surface and breathed. Beside her, Grant Whitmore said nothing for a moment. When he spoke, it was very quietly, beneath the noise. How did you know? He asked. How did you know there was a locker at all? An email, she said. One sentence in a system that was supposed to be secure. Somebody was sloppy. She paused. People are always sloppy somewhere. You just have to be patient enough to find where. Freed crossed the floor toward them with the measured stride of a man deciding in real time how to reframe his position. He stopped at the edge of the defense table and looked at Nia with an expression that had moved definitively past anything resembling dismissal. Where did you find Selway? He asked. Public records, she said. That's not an answer. It's the answer you're getting. She looked at him directly. Mr. Freed, I think you should have a conversation with your client about the memo. He looked at her for a moment that lasted exactly as long as it needed to. Then he turned and walked back to the plaintiff's table. She watched him go. She watched him sit down beside the junior attorneys from Helix Ventures, and she watched the way he leaned toward them and spoke, quietly, and she watched the way they listened, and she watched the particular quality of stillness that settled over the plaintiff's table like weather. Beside her, Grant Whitmore followed her gaze. He knows, Whitmore said quietly. He's just figuring out what he knows. He's figuring out how much of what he knows he was supposed to know, she said. There's a difference. She turned back to her notes. Outside the high windows of Courtroom 14B, the November afternoon was going gray and cold, and somewhere across the Hudson, in a ground-floor apartment on Morgan Street in Jersey City, Patrick Selway was sitting with the weight of what he had written down and what he had agreed to do. And somewhere in Connecticut, his mother was in a facility that cost $11,000 a month and did not know about any of this. And somewhere in the Bronx, Marcus was at Aunt Vera's watching a movie about dinosaurs with a fever that was going down. The world was enormous and ordinary and full of people paying enormous prices for things they had not chosen and things they had. Nia Carter looked at her notes. She looked at the submission on the judge's desk. She looked at the gallery, still buzzing, and at Terrence Webb in the third row with his notebook and his expression of a man who was writing the story he had been waiting to write. At 4 o'clock, Judge Alderman returned to the bench. She looked at the full courtroom with the unhurried authority of someone who had something to say and intended to say it exactly once. The court finds the submitted materials admissible for the purpose of a full evidentiary hearing, she said. The materials raise questions of sufficient gravity regarding the origin and integrity of the document at the center of this case that they require thorough examination before this trial proceeds further. She looked at both tables. I am ordering an immediate evidentiary hearing. Mr. Freed, the plaintiff will have full opportunity to challenge and respond to the submitted evidence. Ms. Carter, you will have the opportunity to present the forensic testimony and witness statement. She paused. This court will also be notifying the relevant federal authorities of the materials submitted today, specifically the memorandum, for their independent review. The gallery erupted again, louder this time. Freed was on his feet, objecting, asking for a continuance, citing procedural concerns, doing all the things that excellent attorneys did when the ground shifted beneath them and they needed to buy time to find new ground. The judge noted his objections. She did not grant the continuance. Nia sat at the defense table with her hands flat and steady on its surface, and she did not feel triumphant. She felt something more measured than triumph, more durable. She felt the specific satisfaction of a thing built correctly, of a process followed with care, of the truth arriving by the route it was always supposed to travel. She felt, underneath all of it, the particular kind of exhaustion that came not from defeat, but from effort. The deep tiredness of someone who had been carrying something heavy for a very long time and could finally, for just a moment, set it down and breathe. She looked at her phone. She had a message from her mother. Marcus's fever broke. He ate dinner. He wants to tell you about the dinosaur movie. She wrote back, "Tell him I'll call at 8. Tell him I found something today." She put the phone in her pocket. She gathered her notes. She looked at the Arcturus memo one last time before it went into the evidence package, at the clean administrative language of a plan, at the two initials at the bottom. RC. Then she put it away and stood up and began preparing for what came next. The first envelope appeared under her door on Thursday morning. She found it at 5:45 when she went to the kitchen for coffee, a plain white rectangle lying on the linoleum just inside the door with the particular deliberateness of something placed rather than slid. Centered, squared to the doorframe, as if whoever had left it wanted her to understand that the precision was intentional, that they had been close enough to be precise. She stood in the kitchen doorway for a moment, in her socks and the oversized Columbia Law sweatshirt she slept in, and looked at the envelope without picking it up. She thought about fingerprints, about chain of custody, about all the procedural architecture of evidence that she had spent the past week navigating. Then she went to the kitchen drawer and pulled out a pair of latex gloves. She had bought a box of them 2 days ago, after the anonymous call, in the same deliberate way that she had started triple-checking the locks before bed and varying the time she left the building in the morning. The envelope contained a single sheet of paper. On it, printed in a plain sans-serif font that could have come from any of 10 million printers. You found what was in the locker. Think carefully about whether you want to open what's inside it in court. Some doors, once opened, can't be closed. Consider your son. She read it twice. She set it on the kitchen table and photographed it with her phone. Then she photographed the envelope, the placement of the envelope relative to the door itself. She put both the letter and the envelope in a clear plastic zip bag she found in the kitchen cabinet, labeled it with the date and time in her own handwriting, and put it in the accordion file she had been using to organize her case materials. Then she made coffee. She was not going to stop. She had understood, since the anonymous phone call, that she was not going to stop, and the understanding had a quality of bedrock to it. Not bravado, not performance, just the specific certainty of a person who is located beneath all the fear and fatigue and reasonable self-preservation, something that will not move. She was afraid. She would be stupid not to be afraid. But fear and stopping were not the same thing, and she had been distinguishing between them for as long as she could remember. What the letter had done, beyond frightening her, was clarify something. Whoever had written it knew where she lived. They knew about Marcus. They had been inside her building, close enough to her door to place an envelope with precision. And they had wanted her to know that. The message was not just the words on the paper. The message was the placement. The message was, "We can reach you." She called Terrence Webb at 6:15. "I need you to hold copies of everything," she said. "The forensic report, Selway's statement, the memo photographs, the USB drive documentation. I need multiple copies in multiple locations outside my apartment." A pause. Something happened. "An envelope under my door, I photographed it." She heard him exhale. "I need the information distributed, Terrence. If something happens to me or to the physical materials before the evidentiary hearing, I need the truth to still exist somewhere. I'll set up a secure cloud repository, he said. Password protected, multiple access keys, one copy with my editor. I'll have it ready in 2 hours. 3 copies minimum, different platforms. Done. A pause. Nia, are you I'm fine, she said. I'm making coffee. She heard something in his voice that she recognized as the particular helplessness of someone who wanted to do more than the situation permitted. She recognized it because she had felt it herself, many times, standing at the edge of something she couldn't fix, holding the inadequate tool of her own concern. Thank you, she said, for all of it. Don't thank me, he said. Just be careful. She was beginning to think that the people who loved her, and Terrence Webb, she had decided in the past 72 hours, was becoming someone in that category, the way people did when they had been through something real together. We're going to say that to her a great deal before this was over, and that she was going to have to keep finding ways to reassure them that careful and stopped were not the same thing. Bad. The break-in happened the following night. She came home from the courthouse at 6:30 to find the accordion file on her kitchen table open, its contents fanned across the surface in the way that wind made things fan, or hands. The window above the fire escape was unlocked. She checked it every night. She was certain she had checked it the night before, and pushed slightly inward from its frame. Nothing was missing. She went through everything twice, 3 times, with the careful inventory of someone who knew exactly what she had and where she had put it. Nothing was missing. That was the point, she understood. Nothing taken, everything disturbed. A message delivered not in words but in the specific violation of a private space, the rearrangement of her careful order just enough to make her feel it. She stood in the kitchen for a long moment, looking at the fanned papers, and felt something move through her that she was not going to call fear because fear was not the right word for it. It was older than fear. It was the feeling of being watched, of being known, of having the small fortress of an ordinary life revealed as permeable. She called her mother. I need you to take Marcus again, she said. A few more nights. I'm sorry, Mama. You don't have to apologize. Her mother's voice was tired in a way that had nothing to do with the hour. Is Marcus in danger? No, she said. They're trying to frighten me, not harm anyone, but I want him with you somewhere they don't expect. She paused. Can you go to Vera's again? We'll go tonight. Thank you. She reorganized her papers. She relocked the window and checked the lock twice. She photographed the disturbed state of the table before she touched anything, with the mechanical precision of someone who had learned that documentation was the only reliable form of protection available to people who didn't have resources. Then she called Grant Whitmore. He answered immediately. She had noticed over the past few days that he always answered immediately, that the ring, once, and pickup had become a pattern, the particular attentiveness of a person who was used to having many claims on their attention and had reorganized those claims in a way that put her at the top. She told him about the envelope, about the break-in. She'd described both with the same factual precision she used in court. No embellishment, no performance, just the clean recitation of what had happened. When she finished, there was a silence on the line that had weight to it. I'm sending security, he said. No, she said. Nia, I'm not having Whitmore Capital security in my building in the Bronx, she said. That changes the story. That makes me look like I need protecting. And the people watching this, the jury, the press, the judge, need to see someone who doesn't need protecting. Someone who stands on their own. She paused. What I need is the hearing. I need it as soon as possible. Every day this drags out is another day they have to try something that actually works. Another silence, then, I'll have my attorneys file for an expedited hearing date tomorrow morning. Good. And the witness, Selway, have you... I spoke to him this afternoon. He's still willing. He's scared, but he's willing. She sat down at the kitchen table, in the chair she always sat in, and looked at the window above the fire escape. He deserves protection, Grant. Proper protection. Not just a promise. His mother's situation needs to be secured regardless of how his testimony goes. Can your people handle that? She heard him register the use of his first name. The first time she'd used it, she realized. She had been careful about the distance between them, careful about the professional maintenance of it, because she had understood from the beginning that the relationship she was most in danger of misreading was this one, the one closest to the heat of what was happening. "I'll personally ensure his mother's facility is secured," he said, "financially, regardless of outcome." "He needs to hear that from you directly," she said. "Not from Patricia, not from an assistant. From you. Can you call him?" "Yes." "Tonight?" "Tonight," he said. She looked at the window. "There's something else. Freed's team is fracturing." "You think so?" "I watched Freed in the gallery after the judge's ruling yesterday. He spent 20 minutes on his phone during the recess. When he came back, 2 of the junior attorneys from Helix's side were in the corridor, and they were not having a comfortable conversation." She had watched that corridor exchange with the sideways attention of someone who had learned to see things from the corners of rooms. Freed is a hired gun. He's exceptional at his job, but he believed the case he was given. Someone told him the story, and he prosecuted the story. Now he's being asked to examine whether the story was true, and that's a different problem for him. "You think he didn't know?" Whitmore said. "I think he didn't know the full architecture," she said carefully. "I think people at Helix may not have known either, at least not the founders. Someone inside their operation was working with Arcturus, but that doesn't mean everyone was." She paused. "There may be someone on the inside who wants to talk." She hadn't said Elise's name aloud yet, because she had only a feeling about Elise, a feeling based on a 2-minute conversation in the courthouse corridor that had lasted exactly long enough for a young woman with anxious eyes and a Helix Ventures lanyard to approach her and say very quietly, "You're asking the right questions," before walking away. She had a feeling about that young woman. She had learned to trust her feelings about people. "I'll follow that thread tomorrow," she said. "Get some sleep." A pause. "You should too." "I know." She didn't. She stayed at the kitchen table until 2 in the morning, working through the evidentiary materials for the hearing, building the structure of the argument with the care of someone constructing something that needed to hold weight. Terrence had sent confirmation that the cloud repository was active, 3 platforms, multiple access keys. Her editor CC'd, a note that read, "This is as distributed as I can make it. They'd have to erase the internet." She read it and felt, for a moment, something that was not quite gratitude, but lived in the same neighborhood. Opa. Elise Navarro was 26 years old, and she had the specific quality of a person who had recently discovered that the organization she worked for was not the organization she believed she had joined. She was a data operations analyst at Helix Ventures. She had been there for 16 months. She had graduated from NYU with a degree in information systems and had taken the Helix job because she believed in what the company said it was doing, building accessible data architecture for mid-sized companies that couldn't afford enterprise solutions, democratizing technical capacity, doing something real in a landscape full of companies that talked about doing something real. She had believed that. She had put in 12-hour days on the strength of that belief. She told all of this to Nia in a coffee shop on Rector Street, 8 blocks from the courthouse, on Friday morning. She held her coffee cup in both hands and talked in the low, slightly rushed manner of someone who had made a decision and needed to execute it before the adrenaline ran out. "When did you first understand something was wrong?" Nia asked. Elise looked at the table. 3 months ago. My direct supervisor, not one of the founders, a VP who came on about 18 months ago, right around the time all of this started, asked me to run a metadata audit on a set of documents that were being prepared for the legal team. It wasn't unusual, that kind of thing was part of my job. But the specific request, she stopped. He asked me to ensure that certain modification timestamps on documents in a specific folder were consistent, and I asked him consistent with what, and he said consistent with the rest of the folder's timeline. "He was asking you to alter metadata," Nia said. "He didn't say that. He said, ensure consistency. But yes, that's what he meant." She looked up. "I didn't do it. I told him the folder looked fine and closed the ticket without touching anything." "Did he follow up?" "He came to my desk the next day and said there were some legacy files with timestamp errors and asked if I'd addressed them. I said yes. I'd reviewed everything and it looked clean." She paused. "I lied to him. Because I understood by then what those timestamps were and why someone wanted them changed." "Which was?" Elise set down her coffee. "The folder contained drafts, not the final contract, not anything that was in the legal submission. Drafts, early versions of the addendum, with timestamps showing that they'd been created on a network outside Helix's infrastructure and then transferred into our system. She held Nia's gaze. Someone had inserted documents into our own document management system and backdated them. The metadata should have been cleaned before they came to me, but whoever did the technical work made errors, small ones, the kind of thing you'd only notice if you were specifically looking at timestamp consistency. Nia felt the edge of everything she'd built sharpening. Elise, those drafts, are they still in the system? I don't know. After the conversation with my supervisor, I flagged the folder in our archiving system with a notation that said it had been reviewed for quality control and locked it from further modification under my user credentials. I don't know if someone with higher permissions went in after me. She paused. But I kept a personal record of what I found. Screenshots, file properties, the works. I have it on a personal drive at home. Will you testify to this? Elise was quiet for a moment. Outside the coffee shop window, the Friday morning foot traffic of Lower Manhattan moved past. The suits and the deliveries and the people on phones and the entire ordinary complexity of a city that did not know and would not particularly care about what was being decided in a courtroom 8 blocks north. I was afraid, Elise said. That's why I didn't go to anyone sooner. My VP knew what I'd done, or hadn't done. And every time I saw him, I thought about what it would cost me to say something. She paused. I'm 26. This is my first real job. I have student loans and a lease, and everything I've worked toward is tied up in this company and my reputation in it. I know, Nia said. I know exactly what that costs. Elise looked at her. Really looked. The way people did when they were deciding how much to trust a stranger. You're not a lawyer, she said. No. But you're doing this anyway. Yes. Why? Nia thought about how to answer that. She thought about the courtroom, the laughter, the phones pointed at her like accusations. She thought about 10 years of library study and hotel rooms and kitchen tables and a son with an ear infection and a mother who drove to Jersey at 7 in the morning. She thought about the anonymous call listing her vulnerabilities and the envelope on her floor and the window pushed open above the fire escape. Because the truth is in the room, she said finally. It's been in the room the whole time. It just needed someone to say it out loud. Elise Navarro looked at her for a long moment. I'll testify, she said. By Friday afternoon, the fractures Nia had seen in the plaintiff's team had deepened into something structural. She knew it because Terrence called her at 3 o'clock with information he'd received from 2 separate sources inside the financial press. One of the 3 founding partners of Helix Ventures had retained independent counsel. The VP who had asked Elise to alter the metadata had not appeared at the company's offices that morning. And Douglas Freed had filed a motion requesting a 48-hour continuance for what his filing described with careful vagueness as material developments in the evidentiary record. Judge Alderman denied the continuance. Nia was in the courthouse conference room when she got word of the denial, sitting across from Patrick Selway, who had come in from Jersey City that morning and was wearing the careful, deliberate clothing of someone who had dressed for something important and had not quite managed to look comfortable in it. Grant Whitmore had called him the previous evening, as promised, and whatever that conversation had been, she didn't ask, and Selway didn't fully describe it. It had produced in Selway a quality of settled resolve that had not been there in the Jersey City apartment. He told me about his mother, Selway said. He was not looking at Nia when he said it, looking instead at the middle distance that people looked at when they were managing something private. He said she had Alzheimer's in the last stages, that he'd understood, looking back, that he had not always made the time to... He stopped. He said he understood about difficult arithmetic. Nia was quiet. He didn't have to say that, Selway said. No, she agreed. He didn't. She went through Selway's testimony preparation with careful thoroughness, walking him through the sequence of events in a way that built the narrative cleanly, what he had been asked to do, what he had done, what he had understood about its purpose, what he had kept and why. She was not coaching him to perform. She was helping him organize, helping him find the structure in what he knew so that when the pressure of the stand came, he would have something solid to hold on to. They will try to make you feel like the worst thing you've done defines everything you are, she told him. Freed, or whoever's cross-examining at this point, will use the money, the templates, the access code. They'll try to make the jury see a man who sold out his employer for 30 pieces of silver. Selway flinched slightly at that. The answer to that, she said, is not to deny what you did. The answer is to let the full truth be present in the room. What you did, why you did it, what it cost you, and what you chose to do when someone finally came looking. She held his gaze. You kept the locker contents for 14 months. You could have destroyed them. You didn't. I told myself it was insurance, he said. Protection. Maybe it was, but it's also evidence, and you gave it voluntarily. She paused. That matters. He nodded slowly. Outside the conference room window, the November sky had gone the particular shade of pewter that preceded rain, and the city below the courthouse was settling into the compressed, hurrying energy of a Friday afternoon that wanted to become a weekend. She thought about Elise Navarro, who would be meeting with the federal attorney's office that afternoon under Terrence's arrangement. A meeting that Nia had no official role in but that she had helped engineer, connecting Elise with a contact at the U.S. Attorney's Office through a law school professor she had kept in touch with across the decade since she'd left Columbia. One of the few people who had consistently treated her continued education as the real thing it was. Professor Diane Okafor had not been surprised to hear from her. That too mattered. The second threatening letter arrived not under her door, but taped to Marcus's school locker. She found out about it because Marcus's teacher called her at 2 in the afternoon. Called her, not texted, which meant it was the kind of thing that required a voice. To say that Marcus had found something on his locker that morning and had brought it to the classroom and shown it to his friends, apparently believing it was a note for him. And when the teacher had taken it and read it, she had immediately notified the principal and called the police and now was calling Nia. Nia was in the conference room when the call came through. She looked at her phone screen for 1 second, PS142, calling, and felt something move through her that was not fear or resolve or any of the things she had been managing carefully for the past week, but something older and more total. The specific terror of a parent who has just understood that the thing threatening them has moved, without warning, toward their child. She answered the call. She listened. She kept her voice level with an effort that cost her more than anything else in the past 10 days had cost her. Is Marcus all right? She asked. He's completely fine, the teacher said quickly. He doesn't understand what the note means. He's in class. He's fine. But, Miss Carter, the note says... I understand what it says, Nia said. She didn't need to hear it. She understood the grammar of it, the escalating logic of people who used proximity to children as a register on the scale of threat. Please keep him in your direct sight until I arrive. I'll be there in 40 minutes. She ended the call. She sat for a moment in the conference room with her hands flat on the table and the particular stillness of someone whose internal landscape had just experienced a seismic event and who was deciding, in the immediate aftermath, who they intended to be. Then she picked up her phone and called Whitmore. They went near Marcus, she said. Her voice was level. It was the levelest her voice had ever been, and that levelness was costing her something she did not have a name for. A note on his school locker. The silence on Whitmore's end was very brief. Tell me the school and the address. I don't want security at his school, Grant. I want this to end. I want the hearing. She paused. And I want someone at the U.S. Attorney's office to know that whoever is running this operation is now placing threats near a 6-year-old child, because that changes the legal calculus considerably. I'll make the call to the U.S. Attorney's office myself, he said, within the hour. And the hearing, Monday, he said. I will make it Monday. She went to Marcus's school. She sat in the principal's office and spoke to the police officer who had been called, and she was clear and factual and organized in a way that she understood was partly professionalism and partly the armor that people built when they could not afford to fall apart in front of others. She documented everything. She photographed the note. She gave the officer Terrence Webb's name and the name of the case. Marcus came to the office at the end of the school day and found her there, and she held him for a long time in the plastic chair outside the principal's door, his head against her shoulder and his ear, that was better now, no longer hot, no longer aching, and she felt his small weight and the total unknowingness of him. He did not know what the note had said. He thought it was an adventure. He wanted to tell her about the volcano they were studying in science, and she held him and thought, no, not this, not him. Not the people she loved as the price of staying. She thought about the anonymous voice listing her vulnerabilities. She thought about the precision of the envelope under her door. She thought about the deliberate calculation of it, the architectural understanding that the most effective threat was not to the person herself, but to the things the person could not protect by being brave. She held Marcus tighter. "Mom," he said, muffled against her shoulder, "you're squishing me." "I know," she said. "Give me one more minute." He gave her the minute. That night, after Marcus was asleep at her mother's, she had moved them there permanently now, 3 blocks away, close enough to reach quickly. She sat at her kitchen table and wrote out, in her careful handwriting, the full account of every threatening communication she had received since the trial began. The anonymous phone call, the envelope under the door, the break-in and the disturbed papers, the note on Marcus's school locker. She described each event with dates, times, and the documentation she had produced. She signed and dated the account and added it to the accordion file. Then she called Terrence and read him the account over the phone while he typed it into the secure repository. "This is everything," she said. "If anything happens to me, everything is in the repository." "Nothing is going to happen to you," he said. "Probably not," she agreed. "But it's good to be organized." She heard him exhale. "You're the most composed person I have ever encountered." "I'm terrified," she said matter-of-factly. "I'm just terrified and continuing at the same time." On Sunday afternoon, Grant Whitmore called to confirm the hearing for Monday morning. Then he said, in the tone of someone raising a subject that they had not been planning to raise, "I want to ask you something." "All right." "Why did you do this?" "At the beginning, the first morning when you walked in. You didn't know me. You had no reason to—" "I knew the evidence was wrong," she said. "I'd been looking at it for 6 weeks. I knew before I walked in that something in that case didn't hold up." "But you didn't know it would turn into this." "No." "So why stand up? Why say, 'I will defend him' in a room full of people who were going to laugh at you?" She was quiet for a moment, looking at the water stain on the ceiling, the one that Marcus had decided was a dinosaur. She thought about how to answer that in a way that was honest without being more than the moment required. "Because the truth was in the room," she said. "Same answer I gave someone else this week. The truth was there, and the only thing preventing it from being heard was that no one was saying it." She paused. "I have spent my entire adult life being in rooms where the truth was present, and no one with the standing to say it was willing to say it. Rooms where I cleaned up after the meeting and read the papers left on the table and understood things that the people who called the meeting didn't understand or didn't want to." She paused again. "I was tired of knowing things and saying nothing." A long silence. "I hired Victor Hale because he was the most expensive defense attorney in the city," Whitmore said, slowly, as if working through something. 35 years, the best cases, the biggest clients. I gave him everything and trusted that money had purchased competence." Another pause. "And then he disappeared, and the only person willing to stand up in that room was someone I would never have thought to call." "No," she said, "you wouldn't have." He was quiet with that for a moment. "I'm sorry for that," he said. She considered the apology. She turned it over in the way she turned over things that mattered, looking at them from multiple angles before deciding what they were. "Work on it," she said. "Don't apologize for it. Work on it." She heard something in his silence that she chose, for now, to leave unnamed. "Monday morning," she said, "get some sleep." She hung up. She sat at her kitchen table in the quiet apartment, the accordion file in front of her, the city doing its Sunday evening things outside the window, and she looked at the stack of everything she had built. The notes, the copies, the documentation, the chain of custody, the thread pulled from the smallest thing, one email, one displaced Oxford comma, one word, locker. And she felt the full weight of it, the gravity of all the work, and all the fear, and all the continuing. She thought about Monday. She thought about a room full of evidence waiting to be heard. She opened her notes to a fresh page and began to prepare. Monday arrived the way significant days sometimes did, quietly, without the fanfare that the weight of them seemed to demand. The sky over the Bronx was clear and very cold, the kind of November cold that had decided to be serious about itself. And Nia stood in her kitchen at 5:30 in the morning and drank her coffee standing up, looking at the accordion file on the table, at everything inside it that had been built across the past 10 days from nothing more than attention and refusal. She had slept 4 hours. She had checked the locks 3 times before bed, and once at 3 in the morning when a sound in the hallway turned out to be a neighbor's cat. She had lain in the dark for an hour afterward, running through the structure of what she intended to say, in the hearing the way a musician ran through a score before a performance. Not to learn it, it was already learned, but to feel its weight and shape, to make sure every part of it was still where she had put it. It was. All of it was. She dressed carefully. She had one suit, a charcoal blazer and slacks she had bought 3 years ago for a job interview at a paralegal firm that had ultimately not called back, kept in the back of the closet since in the way that things were kept when they represented a version of the future you had not yet given up on. She put it on. She looked at herself in the bathroom mirror for a moment, and what looked back at her was not the woman in the hotel apron, or rather, it was that woman, exactly that woman, and also something more than that woman had been permitted to be in public until 10 days ago. She went to her mother's apartment at 6:15. Marcus was still asleep, one arm thrown over the edge of the bed in the boneless way of children, his breathing deep and even. She stood in the doorway of Vera's spare room for a moment and looked at him and felt the whole of it, the fear and the love and the cost and the reason, compressed into the particular silence of a sleeping child's room. She kissed his forehead without waking him. She went back to the kitchen where her mother was already up, already coffeed, already watching her with that lifelong expression of warring things. "Today's the day," Dora said. "Today's the day," Naya agreed. Her mother stood up and straightened the lapel of Nia's blazer with both hands, a small, specific gesture that contained 30 years of meaning, and then stepped back and looked at her daughter the way she looked at things she had made and could not quite believe. "Go," she said. Courtroom 14B was fuller than it had been at any point in the previous week. Word had traveled through the press, through the financial community, through the particular networks of people whose professional lives were bound up in the outcome of cases like this one, and the gallery was packed to its capacity with journalists and attorneys and observers whose collective attention gave the room a compressed, almost pressurized quality, as if the air itself understood that something was being decided. Nia arrived at 8:45. Grant Whitmore was already at the defense table, and beside him, for the first time since the trial began, there was a second attorney, a licensed one, a woman named Carol Eshin, who was a partner at a mid-sized litigation firm and who had agreed at Whitmore's request and on extremely short notice to serve as co-counsel for the evidentiary hearing. Nia had spoken to her on Sunday evening. She was sharp, direct, and had reviewed the full evidentiary submission with the focused intensity of someone who recognized, in the materials assembled, work that she respected. "You built this cleanly," SCN had said on the phone without preamble. "The chain of custody is solid. The forensic documentation is solid. Selway's statement is organized and specific." A pause. "You should have been practicing law 10 years ago." "I know," Naya had said. Now Essien looked up from the defense table as Nia took her seat and gave her a brief, direct nod. The nod of one professional acknowledging another, without ceremony or qualification. Across the aisle, the plaintiff's table looked different. Douglas Freed was present, but 2 of the attorneys who had flanked him throughout the trial were absent, replaced by a single junior associate who had the particular look of someone who had been given an assignment they had not anticipated and was managing it with determined professionalism. The Helix Ventures representatives who had occupied the row behind the plaintiff's table every day were absent, except for one, a man Nia recognized as one of the company's original founders, who sat with his hands folded on the table and the expression of someone who had spent the weekend learning things about his own organization that he wished he didn't know. Freed looked, for the first time since she had walked into this courtroom 10 days ago, in a housekeeper's apron, like a man who was carrying more than he had come in with. She understood why. Terrence had confirmed on Sunday night that the U.S. Attorney's Office had received not only Whitmore's call, but also a separate approach from Elise Navarro, represented by her own attorney, requesting a proffer agreement in exchange for her full cooperation. The office had moved quickly. The speed itself was information, a signal that what Elise had brought them connected to something they had already been watching. The bailiff called the room to order at 9 o'clock precisely. Judge Alderman took the bench and looked out at the assembled room with the expression of someone who had seen many things in 23 years and had decided that the appropriate response to most of them was to proceed with clarity. "We are here for the evidentiary hearing ordered by this court on the matter of the defense's submission," she said. "Ms. Carter, Ms. Essien, the defense may proceed." Carol Essien handled the opening framework, laying out the evidentiary architecture with the crisp efficiency of an experienced litigator, establishing the chain of custody, the credentials of Dr. Yolanda Marsh, the legal basis for the submission. She was precise and effective, and she moved through the procedural foundations quickly, clearing the ground. Then she turned to Nia and gave a small nod. Nia stood up. She had thought about this moment, about what it required of her, about the difference between the opening statement 10 days ago and this. The opening statement had been about creating doubt, introducing a question, shifting the frame just enough to make the room uncertain. This was different. This was about the answer. She called Dr. Yolanda Marsh first. "Doctor." Marsh took the stand with the settled authority of someone who lived in the landscape of contested facts and had learned to be the stillest person in any argument about them. Nia walked her through the USB drive contents methodically. The 4 draft versions of the addendum, the metadata showing external network origination, the timestamp progression, the documented evolution from Whitmore Capital's authentic templates to the fraudulent final version. Fried cross-examined with skill, pressing on the limitations of VPN tracing, on the possibility of alternative explanations for external network metadata, on the theoretical scenarios in which the draft evolution could have a benign interpretation. Dr. Marsh answered each challenge with the patient precision of someone who had anticipated it and had the technical ground to hold. "Dr. Marsh," Fried said in his final question, "you cannot, with certainty, identify the person who created these draft documents. Is that correct?" "The digital forensic evidence identifies the network origin and the document evolution," Dr. Marsh said. "Individual attribution requires additional evidence," she paused, "which is present in the other materials submitted to this court." Fried sat down. Nia called Patrick Selway. He walked to the stand in his careful clothes and took the oath and sat down. And for a moment the courtroom was very still with the specific attention of a room that understands it is about to hear something that matters. He looked at Nia. She looked back at him steadily. "Mr. Selway," she said, "please tell the court, in your own words, what you were asked to do 14 months ago and what you did." He told them. He told them all of it. The approach from the Mercer Strand associate, the financial arrangement, his mother's facility, the Zurich packet templates, the access code to Whitmore Capital's document management system, the locker package, the memo he had received by mistake and kept for reasons he had told himself were self-protective and now understood were something more than that. He told it without embellishment and without minimization, in the flat, factual cadence of someone who had decided that the only version of the truth worth telling was the complete one. Fried cross-examined him hard. He went after the money, the deception, the access code, the fundamental fact that Selway had knowingly provided materials that were used to harm an innocent man. He was skilled and thorough, and he made Selway work for every sentence. Selway did not collapse. He did not qualify or retreat. He acknowledged everything Fried put to him. Yes, he had taken money. Yes, he had known it was wrong. Yes, he understood the harm that had resulted, and he held through all of it to the center of what he had come to say. "Mr. Selway," Fried said near the end, his voice carrying the particular weight of a man deploying a final resource. "You're asking this court to believe the testimony of a man who sold out his employer, who participated in document fraud, who took payment to enable a conspiracy, and who only came forward when a woman he'd never met knocked on his door and offered him a path to reduce culpability." Selway looked at Fried for a moment. Then he said quietly, "She didn't offer me anything. She asked me to tell the truth. She said the truth was in the room and it needed someone to say it." He paused. "I should have said it 14 months ago. I didn't. I'm saying it now." The room was very still. Fried sat down. Nia called Elise Navarro last. Elise came to the stand looking like someone who had made a decision about who they were going to be and had dressed for it, composed, direct, with the particular steadiness of a person who has moved through fear to the other side of it and found that the other side was simply themselves. She described what she had found in Helix's document management system: the inserted drafts, the timestamp inconsistencies, the VP's request to alter metadata, her decision not to comply. She described the personal record she had maintained, the screenshots, the file properties, the documented evidence that someone had introduced fabricated materials into Helix Ventures' own systems to create the appearance of an organic whistleblower trail. She described how the whistleblower had not, in fact, come from inside Helix Ventures. She had traced the communication pathway herself, she said, quietly, on her own time, after she understood what she was looking at, and the path led to an external consulting firm that shared a registered agent in Delaware with Arcturus Capital Partners. When Freed rose to cross-examine, he stood for a moment without speaking, in the way that lawyers sometimes stood when they were deciding which of several bad options was least bad. Then he sat back down. "No questions," he said. The gallery made a sound that was not quite a gasp and not quite a murmur, but something between them. The sound of a room absorbing a fact. Nia returned to the defense table. She sat down. She looked at her notes, at the 11 pages of careful handwriting, at the thread pulled from a single displaced comma and a single word on a document trail. She thought about 5:30 in the morning and the accordion file and the water stain on the kitchen ceiling that Marcus had decided was a dinosaur. She thought about all of it. Then she stood up one more time. "Your Honor," she said, "the defense requests that the charges against Grant Whitmore be dismissed in full. The evidence before this court demonstrates, with documented forensic verification and corroborating witness testimony, that the central document in the plaintiff's case, the addendum on which the entire fraud allegation rests, was fabricated outside Whitmore Capital's systems, inserted using access obtained through deception, and submitted to this court as part of a coordinated scheme to force a hostile acquisition through manufactured criminal liability." She paused. "Mr. Whitmore did not defraud anyone. He was the target of a fraud. The court has before it the full architecture of that fraud, verified and documented. We ask that it be recognized as such." She sat down. Judge Alderman looked at the submission. She looked at the plaintiff's table, where Douglas Freed sat with the contained stillness of a man who had prosecuted a case in good faith and had arrived at the understanding that the case had not been given to him in good faith. She looked at the Helix Ventures founder, who had not moved for the past 20 minutes and appeared to be reckoning with something private and significant. She looked at Nia. She was quiet for a long moment that the courtroom did not fill. Then she said, "I'm going to take a brief recess. When I return, I will give my ruling." The recess lasted 18 minutes. Nia spent them at the defense table. Whitmore sat beside her, and for the first 18 minutes of silence they had spent together, neither of them felt the need to fill it. Etienne reviewed her notes. The gallery buzzed at a restrained frequency, the sound of people who understood they were near something and were trying to process it before it arrived. At one point, Whitmore said quietly, "Whatever happens—" "Wait," Nia said. "Wait until after." He waited. Judge Alderman returned to the bench at 10:47. She settled her reading glasses. She looked at the room with the composed authority of someone who had reached a decision and intended to deliver it cleanly. The evidentiary materials submitted by the defense establish, with sufficient credibility and forensic documentation, that the document central to the plaintiff's case was not authored by the defendant or by anyone acting under his direction. The evidence further establishes a plausible and documented scheme by external parties to fabricate that document and introduce it into these proceedings for purposes unrelated to legitimate legal redress. She paused. The court finds that the plaintiff's case, as originally constituted, cannot survive this evidentiary record. The charges against Grant Whitmore are dismissed in full. She looked at both tables. Additionally, this court is referring the matter, including the Arcturus Memorandum, the forensic documentation of document fabrication, the testimony of Patrick Selway, and the supporting materials provided by Elise Navarro, to the United States Attorney's Office for the Southern District of New York for investigation of potential criminal conduct, including wire fraud, evidence tampering, and conspiracy. She paused. Court is adjourned. The gallery broke open. It was not the orderly release of tension that courtrooms were supposed to have. It was louder than that, more human. The sound of people who had been holding something for a long time and were finally putting it down. Journalists were on their phones before the judge had fully descended from the bench. The Helix Ventures founder had his face in his hands. At the plaintiff's table, Douglas Freed was very still, and then he stood up and began collecting his materials with the methodical efficiency of a man processing a significant event by returning to procedure. He paused as he passed the defense table. He looked at Nia with an expression that had moved entirely past anything resembling the satisfied dismissal of that first morning. "You built a clean case," he said. It cost him something to say it. She could tell. From nothing, in 10 days. "The evidence was already there," she said. "I just followed it." He nodded once. Then he walked out. Titte. Outside on the courthouse steps, the cameras were waiting in the kind of numbers that Nia had not encountered before. Not the handful of journalists from the first morning, but a significant press contingent, cameras and microphones, and the forward-leaning energy of people who had a story and needed it on record. She and Whitmore came out together. She had not planned it. They had simply walked toward the exit at the same time, and it had become together without discussion, the natural result of 10 days of standing in the same direction. The questions came immediately, overlapping, a wall of them. Whitmore raised one hand briefly, the practiced gesture of someone who had managed press conferences before. The questions didn't stop, but they organized themselves slightly. "Mr. Whitmore, your reaction to the dismissal. Miss Carter, what does this mean for you personally? Mr. Whitmore, do you have a comment on the referral to the U.S. Attorney?" Grant Whitmore looked at the cameras for a moment. Then he looked at Nia. Something passed between them. Not a conversation exactly, more like a recognition, the acknowledgement of two people who had been through something real and were standing, intact, on the other side of it. He stepped slightly back. It was a small movement, a single step, but it meant, "You first." She looked at the cameras. She thought about what she wanted to say, not what was strategic or polished or calculated to land well in a headline, but what was true. Grant Whitmore did not commit fraud, she said. He was the target of a scheme built by people who believed that if you have enough resources and enough technical sophistication, you can manufacture a version of reality that replaces the true one. That you can take an innocent person and bury them under fabricated evidence, and that no one will look closely enough to notice the difference. She paused. They were wrong. The truth was in the room the whole time. It just needed someone to say it out loud. A journalist near the front. "Ms. Carter, you're not a licensed attorney. How did you—" "I studied," she said simply. "For 10 years, I studied. Not because I was planning this. I wasn't. But because the law matters, and understanding it matters, and I refused to let circumstances convince me that understanding was a privilege I wasn't entitled to." She looked at the cameras steadily. There are a lot of people in this country who know more than they're credited for, who understand more than the rooms they're permitted to occupy suggest, who have been told, in 100 ways, that their knowledge doesn't count because it didn't come with the right credentials or the right address or the right zip code. She paused. I want those people to understand something. The truth doesn't check your credentials before it lets you find it. Terrence Webb was at the edge of the press group, not filming, just watching, with his notebook held loosely at his side. He caught her eye. He gave her the small nod of someone who had been in it with her from the beginning and was glad to be standing where they were standing. She gave him the same nod back. 3 months later, the People's Law Project opened its doors in a second-floor office on Fordham Road in the Bronx, 4 blocks from the library on Jerome Avenue, where Nia had spent 10 years at a corner desk with downloaded case files and a legal pad and the stubborn conviction that knowledge was worth keeping even when no one was watching. You keep it. The office had secondhand furniture and good lighting and a small waiting room that was full on the first day of people who had heard about it through the networks by which news traveled in communities that the formal channels of information had historically not prioritized, through churches and barbershops and group chats, and the specific word of mouth of people who had been waiting for something without quite knowing what they were waiting for. There were workers who had been cheated by employers and didn't know their options, tenants who had received illegal eviction notices, small business owners who had signed contracts they hadn't fully understood, whistleblowers who knew something true and were afraid of what it would cost them to say it. Nia met with each of them. She had, by that point, filed her application for reinstatement to Columbia Law's program. a conversation that had begun with a phone call from Dean Margaret Park, who had seen the coverage of the case and had said, over the phone, with the directness of someone who had been watching a situation and had decided the situation required direct action. We should talk about how to make this right. They were making it right. It would take time. Bar admission required completion of the degree, the bar exam, the character review. But it was moving, and in the meantime, the project operated under the formal supervision of Carol Essien, who had agreed to serve as supervising attorney and had brought 2 associates with her who had looked at what Nia had built in 10 days and decided they wanted to be in a room where that kind of thing happened. Patrick Selway had entered into a cooperation agreement with the U.S. Attorney's Office. His mother remained in her facility in Connecticut. The arrangement Whitmore had made was in place and was, as far as Nia could determine, being honored without drama or contingency. The quiet follow-through of a man who had made a commitment and understood now something about what commitments cost and why they mattered. Raymond Chalk had retained 4 attorneys and was cooperating with a defense strategy that his representatives characterized publicly as vigorously contesting all allegations. The investigation was ongoing. These things took time, but the architecture of what had been done was documented and distributed and existed in multiple copies on multiple platforms, and it was not going to disappear. Terrence had published his piece, a 12,000-word investigation in The Current that had been read in its first 2 weeks by more people than anything the publication had previously run. The world knew the shape of what had happened. Elise Navarro had been offered a position by 2 different technology companies in the weeks after her testimony. She had taken neither. She had instead called Nia and asked if the project needed someone who understood document systems and metadata and the specific vulnerabilities of organizations that stored their truth in digital formats that could be altered by people with sufficient access. She was in the Fordham Road office on the first day, at a desk near the window, setting up a system for intake and documentation with the focused thoroughness of someone who had learned the hard way what happened when records weren't properly kept. Grant Whitmore had offered, in the weeks after the dismissal, to fund the project in full. Nia had thought about it for a long time. She had sat with the offer and turned it over and examined it from every angle, because she understood that how you funded a thing shaped what the thing became, and she was very clear about what she wanted the project to be. "I'll accept seed funding," she had told him. "Enough to get the doors open and the first 6 months running. After that, the project needs to be self-sustaining. Grants, community fundraising, pro bono partnerships. It can't be a Whitmore project. It has to be a people's project." He had looked at her with that expression she had come to recognize, the one that meant he was revising something. "You're going to spend the rest of your career turning down money," he said. "I'm going to spend the rest of my career knowing what money is for," she said. There's a difference. He had provided the seed funding. He had not attached conditions to it. She had chosen to believe that the absence of conditions was the beginning of him understanding the difference. They had lunch occasionally, now, not often, and not in the way that would make a story of itself, but in the straightforward way of 2 people who had been through something together and respected what the other had contributed to surviving it. It was not a friendship exactly. It was something more specific than friendship, shaped by the particular circumstances of its origin. The 10 days and the apron and the accordion file and the truth in the room. It was the relationship of people who had seen each other clearly under pressure and had found that what they saw held up. It was, she thought, enough. It was more than she had expected. 1 year after the first morning, 1 year after she had walked through the gate of Courtroom 14B in a hotel apron with a cracked phone and 240 pages of downloaded SEC filings, Nia Carter stood at the front of a room on Fordham Road and looked at the people in it. They were ordinary people, all of them. A delivery driver who had been misclassified as an independent contractor for 7 years. A home health aide who had witnessed something at her agency and was afraid. A young man from Mott Haven who had signed a lease with a clause that his landlord was now using against him in ways he hadn't understood when he signed. A woman who had worked at the same company for 14 years and had been passed over for promotion 11 times and had, in a drawer at home, documentation of every single one. People who knew things. People who had been waiting for a room. Nia looked at them and she thought about the first morning, about the laughter, the phones, the apron, the 240 pages, the accordion file, the thread pulled from a comma. She thought about Marcus asking why she was still in her clothes from yesterday. She thought about her mother straightening her lapel at 6 in the morning and saying, "Go." She thought about Terrence in the third row with his notebook, about Elise at her desk near the window, about Patrick Selway at a table in Jersey City beginning to write. She thought about what it meant that the truth had been in the room the whole time, waiting for someone who refused to stay silent. "I want to tell you something before we begin," she said. And the room went quiet in the way that rooms went quiet when they recognized that something real was being said. Every one of you is in this room because you know something true, and you're trying to figure out what to do with it. Some of you are afraid. Some of you have already paid a price just for knowing what you know. She looked at them, at each of them, in the specific way she had of looking at people that made them understand they had been seen. That's going to change. Not because the world suddenly became fair, but because you're here, and because the truth doesn't require permission to be true. She paused. It only requires someone willing to say it. Outside the window, the Bronx went about its business. The buses and the bodegas and the people and the noise of a borough that had always contained in its ordinary complicated life more intelligence and more determination and more knowledge than the rooms it was permitted to occupy had ever given it credit for. Inside the room on Fordham Road, the people who had come to say true things leaned forward, and Nia Carter began.